Practitioner remuneration,
Certainly.
pre-preference claims.
Certainly, those are you're going to decide whether to put up the preference. That's clear. It could be, but they certainly have the negotiation. Give me additional security, etc., etc. But you see, if business rescue is going to work, it doesn't help. Remember, there has to be a risk in the company. So, yes, it may go into liquidation, but those are part of the risks that you take on as a financier. It's inherent in your equation. You say, have I got security? Have I not? It's no point, I'm trying to remember the judgment. It's not, the business rescue is not designed for the company that's at death's door that's going to die. It's not designed for that purpose. It's designed to turn around companies that have got a prospect of being rescued. And so that is what you're dealing with here. So
terminally ill.
Not terminally ill is the language that was used, correct. So, you know, you're not going to, on that basis, put...
You want them to survive.
Yes, you want them to survive.
ICU.
And so they've got to come together with a proper, take those risks and you will assess them. That's what creditors do every day. They've got credit committees, that's what they do.
Thank you.
Reporter, is there no incidence of cramming down or bullying amongst pre-voting interest holders?
Well, you're voting in accordance with your skin in the game. So you calculated, let's say there's 100 million that's owed to creditors. If you've got a 10 million rand debt, you get a 10% vote. That's really how the voting interest works. It's simple as that. Am I saying that that's the most fairest way? Well, maybe there may be other considerations, but it's the way we've applied for more than 100 years. It's what's happened in insolvency matters for forever.
So you say because it's insulated by the interpretation you provide. There's nothing.
Correct. It's what's always happened. It's how democracy works. We do that.
Because I think your submissions are premised largely on this bullying and cramming down or cramming down.
It's one of the factors. It's one of the factors. If I may be clear, what we're saying is that what did the legislature intend? We say the language favors our position because of the way it talks about post-commencement creditors a vote. It doesn't say so expressly. There's no indications that it does that.
Yeah.
It's also consistent with the Insolvency Act. And then we say one of the factors is you're getting somebody else to vote on your plan. It's just one of the factors.
But at the end of the day, you agree, or there is a potential of bullying even with the creditors pre-commencement. Those who definitely hold a larger voting interest would have a big...
The reason for that is that it's simply related to how much money they have invested. And so that's in principle.
It's the same reason with the post-commencement.
No, but...
They would come in with a larger, injection of capital and then acquire a larger voting interest and therefore, be able to bully the pre-commencement voting interest holders.
Can I tell you what the difference is? The difference is that if I'm bullying myself in the first scenario. I'm not bullying somebody else. So in other words, I'm going to take, if I say it's 10 cents in the rand, I've got to take a 10 cents in the rand loss. That's scenario A for a pre-commencement creditor. Scenario B for a post-commencement creditor who comes in and says, I'm not taking any compromise here. I want my full claim. And he says, you're going to take so much. It's a very different scenario. And the vote is very proportional. It's proportional into how much you have, how much you've lent to the company. So it's a very different scenario to the post-commencement finance because the proportion by which you are crammed down is the same. Okay. That's the difference between the two positions.
I still don't see the difference, but I hear your argument.
Yes, yes.
So my next question relates to Section 152.
Yes.
And what is set out there as what should be included in the proposed business plan. Yes. It seems to me that the language in A, well, in all the different parts, A, B, and C, really sets bare minimums and does not exclude other information that could be brought into the business plan. It says which must include at least. It does not set an upper limit. Am I right?
Agreed, and of course a business rescue plan would include any number of different things, but the reason we submit it sets this as a minimum is because that's going to determine who's voting, how much the vote is, and that's the point. That's why it has to be in there. And more importantly, for purposes of 153,
Well,
the probable dividend you're going to get.
My thinking was that it's expressed as it is because there could be instances where there wouldn't necessarily be an outside funder to make the plan work.
Well, then you would have said post-commencement
Let's
financiers.
just finish.
Yes.
Legislature wanted to ensure that the pre-commencement datas are put in, but it does not necessarily mean, or it does not mean in the language of the Act, that the post-commencement creditors are excluded in the language of the section.
They're not excluded, but the point is that it's not compulsory in the sense to put them in because they have a different interest. Now, you wouldn't have a business rescue plan without what the post-commencement finance would be. It just wouldn't exist. So, but it's not said because it doesn't tell you how these voting interests are going to work.
Wouldn't it be simply a restructuring of the company within itself?
Yes, of course, and you don't have to have a post-commencement finance.
Yeah, that's what I'm saying.
Yes, of course.
Necessarily.
But if that was the intention, you would have said post-commencement, if any. You know, you could have put it in there. It's not as important because otherwise how do you balance these interests, we say?
Okay. But it has chosen to put it at a minimum and
Yes.
exclude it.
Yes, certainly. But that isn't a reason.
Thank you.
Mr. Bota, you made the example that in liquidation proceedings, the claims that arise after the concursus creditorium are treated as part of the administrative costs. In that sense?
No.
No.
No, sorry.
Just correct me.
Yes, sorry, Justice Nuku. The concursus creditorium share in everything that happened prior to the date of liquidation commencing. And then those are the dividends that are paid. The ones who come later are part of the costs. In other words, everyone who's outside of it. So if you continue to transact with the liquidators, the liquidated company through the liquidators, then you are part of the cost of liquidation.
I thought that was what I was saying.
Oh, I apologize, then I misheard you. Apologies.
That's what I meant to say.
Yes.
So in that sense, their rights are not affected by those proceedings because there's a different regime that applies to them.
Correct.
Now, if we must come to the business rescue proceedings, how are those claims treated at the time when the business rescue plan must be adopted?
So my submission is that SAPOA's conclusion is not correct.
No, just give me,
But what should happen, but in large terms, it's contractual. So it's contractual. So in other words, you must be paid out of those costs. If you're going to contract with the company, it should be part of the company as money that's available. So how would it work every day? Let's say you're running a bottle store. South African breweries, you're going to business rescue on
Sorry,
day one.
can I interrupt you? The short answer is that they are not dealt with as part of the cost for the supervision of the company.
It should be. Is our
Is that
submission.
how it's,
That's
the one
our
feature
submission.
in the business plan that will be voted, is that how it works practically?
That's how I submit it should be, and it will actually be practical because where you're going to get the funding from, it'll be everything post-commencement. So what will happen, for instance, as I said, if you're running a bottle store, if you want to get beer from after business rescue, South African Breweries is not going to give it to you on credit unless you do post-commencement finance. They will deliver cash on delivery. So it's going to be contractual. That's how it's going to work. So even if SAPOA is right, it'll then be a contractual matter. That's how it would have to work. In other words, they're not part of the waterfall of pre-commencement creditors. They are later. At most, they'll be consented post-commencement creditors who are dealt with under post-commencement regimes under the payment waterfall under 135.
I'm not quite sure if I understand your answer. My simple question is this: there are claims that arise after the commencement of business rescue proceedings. And so how are those claims treated? You say they are treated as part of the administration. Is that what you are saying?
Yes.
Such that they get paid before any consideration is done to the pre-commencement
Yes.
creditors.
Yes, that is my submission. That's how it should be dealt with. The reason is because that's post the event.
Because if that is so, then it may make sense for them not to vote because there's nothing,
Yes.
they won't be affected. But we just have to be certain about that because
Yes.
it seems pretty much clear in liquidation proceedings, but I'm not so sure if it's that clear in business rescue.
What would happen, let's use the example in this case. Mashwai comes after the event. Mashwai buys, in this case,
Because, sorry, if
yeah.
that were to be the case, then the claim by the creditor we're concerned with here would then have been factored in to be paid as part of the administration.
so it would, if it's not part of the administration costs, if it's considered post-commencement finance, it follows in terms of the payment waterfall under 135, and that'll be how it'll work. But remember, they come with knowledge after the event. But if you look at what happened with Mashwai here as an example, what they said is they wanted the rail allocation. They bought the rail allocation, and they paid in advance for it. That's their argument. They say that makes them a creditor. They are a creditor really for the performance of the rail allocation over the rest of the period. Now the question is, where do they fit in this scheme? We say they don't get a voting interest because they've come afterwards. They've bought this rail allocation. They know what they've got. That's what they're dealing with. We argue that they shouldn't be creditors, but we accept that they are for purposes of this debate. Under post-commencement, it's a concession I made in the court ar quo, and I made the concession in the court of first instance. We accept them as a post-commencement creditor, but they will be dealt with through that mechanism. If I'm not right that they are part of the costs of the supervision, they will be dealt with under the payment waterfall under 135 sub 3.
But if you look at section 145.4,
Yes,
which determines the voting interest,
yes.
it seems to me that it is the value of the amount owed to that creditor that determines the voting interest.
We say that that only applies to the pre-commencement. That's the thrust of this debate, not post-commencement.
But that section does not seem to say that it contemplates that secured creditors will have a vote, which is equal to what is owed to them. It talks about unsecured creditors, and then it talks about concurrent creditors. You made some reference to the fact that the post-commencement creditors may have security, but it seems as if even whether you have security, you are still entitled to the vote. So how do we get to this?
No, we say when it's talking here about a voting interest equal to the value of the amount owed to that creditor by the company, you must read that as at when the business rescue took place, because otherwise the whole regime doesn't make any sense. Look, there's a lot about the language, unfortunately, that is not great here, because why would you use secured, unsecured, and then concurrent? Concurrent creditors are generally unsecured creditors. So
But
they,
in my mind, that
but-
seems to suggest that secured is secured, unsecured may be a creditor who's unsecured but has some preference. And then you have concurrent creditors.
well,
That's-
except the difficulty with that proposition, Justice Nuku, is that it says a concurrent creditor who would be subordinated in a liquidation. So B is only dealing with one scenario. So it only gives a way to value that, because then you go into a valuation regime which follows in the rest of the provisions. The only way to value that. So the concurrent creditor, it's strange that they do this language. You talk about secured, unsecured, and then you talk about a concurrent creditor that will be subordinated in a liquidation. That we point out in our head seems to be, and as per the commentary, and Henoksburg agrees with the submissions we make, that this deals with somebody who has subordinated their debt in favor of other creditors, and so therefore your voting interest is not going to be the same as a normal creditor. But we say all of this should be pre-commencement in this section 145 sub 4.
And then lastly, I'm not sure if I understood you correct to be saying that section 135 regards the remuneration of employees post the commencement of business rescue proceedings as post-commencement finance. Is that correct?
Correct.
And then in relation thereto, there is a specific cap of their right to vote.
Yes.
But no other post-commencement creditor's right is capped. Should you read anything to that?
Yes, we say it means post-commencement creditors don't have a cap.
But it
Don't have a right to vote. That's what I-
identifies the employees in particular
Yes,
in relation to their claim for post-commencement claims, that they won't be entitled to vote.
that's what we say.
Then it says nothing about other post-commencement creditors.
The assumption being post-commencement creditors are not going to vote. That's the point.
If that were to be the case, would it have been necessary to single out the employees? That's my question, really.
Well, that's because they're giving them an additional right, because the employee doesn't otherwise have a right to vote. So what it's making clear is that for pre-commencement debts, it has a right to vote as an employee, as a creditor, in effect. That's what Section 144 in the employee's rights is saying. But it limits it only to that. It doesn't give them post-commencement rights.
One, just for clarity, when you say the post-commencement commencement creditors are not allowed to vote, why should that be the case when they've invested monies to save this ailing company? And also when one has regard to Section 7 of the Act 7K of
For all the reasons that I've submitted, firstly, the balancing of the rights and interest under Section 7 protects both the pre-commencement and the post-commencement. They have a remedy under Section 135(3). They are a preferred creditor. They don't get a right to vote because then they would be voting on other people's rights. Their rights are not affected in the same way. It's only pre-commencement debts that are there. Section 150, it's really my entire argument. Section 150 doesn't give you an indication that they would vote. Voting interest traditionally under the insolvency is all before. The balancing of the rights and interest is struck by adopting the approach that we adopt, which is to say, even though they've added money after the event, that doesn't mean that they get to vote in regard to a plan that's going to affect rights that were before the event of business rescue. That is our submission. That's the way you balance all the rights and interest. Everyone has got their different stakeholders, and that interpretation of the Act gets the best balance, as opposed to having somebody coming later dictating terms to someone who was there earlier.
Both, just one question from my side. It's just a clarification one. Is it your submission that we should interpret post-commencement financiers not as creditors? And if so, does the wording of Section 145, when it says each creditor, should that be construed to exclude the post-commencement financiers?
No, that's not my argument. We've said
What is the argument?
the argument is that they are creditors, but they don't have
We're talking voting.
Yeah,
I mean,
voting.
Don't forget.
Only voting.
Yeah.
So they don't have a voting interest. That's what our argument is. So they may be a creditor in the broad sense of that definition. Money is owed to them. Of course, once you've advanced money, you are a creditor. They would have other rights under 145. What they don't have is a right to vote, we say, because they don't have a voting interest in the context of the provisions. So in other words, it's just the voting on the plan. They have other rights that they would have, which are there.
Thank you, Mr. Potter.
Thank
We'll take a tea adjournment for 20 minutes.
As please.
Court adjournment.
we would refer to paragraphs 59 to 61 of our heads of argument, or written argument, where we've analysed from a practical point of view what happened in the court of first instance. And we start at paragraph 59, where we say that in counter-applying as aforesaid, the practitioner, Arno, and Mshwayi all recognised that the approval of the plan by the creditor stood until and unless it was set aside by the court, and that was reliance, of course, on the Odekrol decision, and then that the practitioner, Arno, and Mshwayi therefore all bore the onus of satisfying the court that they were entitled to the orders that they sought, and they failed to do so. And so in paragraph 61, on an application of the principle that PCF creditors could not vote on the approval of the business rescue plan, the High Court was entitled to consider whether, on the evidence before it, sufficient votes had been cast for the approval of the plan by the creditors who were entitled to vote. And as appears from the judgment, we say, the High Court was so satisfied and accordingly declined the counter-applications to set the vote aside. And we make the point again in paragraph 62 that we made earlier. I know making a point over and over again doesn't make it stronger, but that as appears quite clearly from the two judgments of the Court of First Instance, all of the parties in the High Court proceedings accepted that but for Mshwayi's votes, the statutory threshold was met for the adoption of the business rescue plan in terms of section 151, read with section 150 of the Act. The point I made in opening is that Ndalamo and Salangano both pressed for an interpretation of the provisions of section 145 that restrict the meaning of creditor who can vote on the approval of a business rescue plan, based mainly on a purpose of interpretation to exclude post-commencement creditors. We just simply point out, in addition to what Mr. Botha has argued, that the test is an objective test and fully addressed from all the parties' points of view, and we submit from our own too in the written arguments. In our heads of argument, we have referred fairly extensively to academics and commentators on the topic of Chapter 6. These are from our heads of argument, page 17, footnote 42, to page 18, and the reasoning that is reflected therein. Not highlighted specifically therein is the position concerning employees. We just point out, to clarify this, because it was the topic of several questions to Mr. Botha, that section 135 describes post-commencement remuneration of employees as post-commencement funding. That's in section 135 1A. Then section 135 sub 3 sub 1 confers a super preference on employees in respect of the post-commencement finance that is constituted by their post-commencement remuneration. Then section 144.2, read with 144.3F, limits the vote, as Mr. Botha took you through, to pre-commencement unpaid remuneration. It limits the right of employees to vote after the commencement in respect of the adoption of a business rescue plan to acting as a creditor and voting in respect solely of the pre-commencement portion of its claim. CASM MF, who's referred to in our footnotes on the articles and textbooks that we refer to in our heads of argument, submits and opines, and we submit that all post-commencement creditors should be treated in the same way, that there's no reason to exclude employees from the general body of creditors, and in fact to treat funding creditors differently to employees who supply their labour even after the commencement of the business rescue process, as Justice Collopin suggested to Mr. Botha, often with their hands tied behind their backs. Then, in the course of questioning, Mr. Botha and many learned justices referred to various scenarios that could arise on a practical level in the course of a business rescue proceeding, such as that which is before the court today. We think and submit that nothing could be clearer to show exactly how the funding works than Circular 14, which is in the papers in volume 11 of the record. And it starts at page 1044. It's annexure MFA 3. And it is a circular to all known creditors and other affected persons of Honor OPCO. And it speaks of the publication of a proposed business rescue plan, and it goes on and talks about the intended meeting, and I'm not going to take you through all of that, but we want you to page forward, please, if you have it, to paragraph 3.7 on page 1047, where one finds the Ndalama offer at 3.7.1 and following, and at 3.7.2, the Mshwayi offer. Now, by the time that these were voted on at the meeting on the 25th of July, the principal, if I can call it that, the principal offer, the main offer had been voted on, the one that is the subject of the vote that's being impugned. That had been voted on, and that led to a voting on the various alternatives that were postulated or had been presented under 3.7 and were explained to creditors so they could decide who to vote on. And this is really for illustrative purposes that I draw your attention to this, but the Ndalama offer, as appears from 3.7.1.1, was the first binding offer received, and it was for the acquisition of the business of Honor OPCO for a price consideration of 435 million rand. And the price consideration of 435 million rand was made up of 70 million rand to settle creditors' claims, both pre- and post-business rescue, to be distributed at the discretion of the BRP, and then an amount of 365 million rand was provided or would be provided as post-commencement funding to fund the refurbishment of the existing plant and related infrastructure, recapitalization and development, acquisition of surface rights, etc. The PCF amount would be converted into equity. The PCF amount would only be repayable by the company to Ndalama if the proposed transaction failed for any reason whatsoever. And the 70 million rand to settle creditors' claims for both pre and post would be paid on Section 11 ministerial approval. So what this exemplifies is how post-commencement funding can be provided and often is provided in the context of a business rescue procedure. The creditor here in Ndalama could impose conditions. It obtained security in the form of the equity that would be issued to it. The claims would be paid once the condition of Section 11, the statutory a requirement of Section 11 ministerial approval would be obtained, and so it went on. And then, in contradistinction to that, was 3.7, I beg your pardon, point 2, which was the Mshwayi offer. And Mshwayi offer is dealt with on page 1050. The second binding offer received by the BRP was from Mshwayi, a special purpose vehicle to be incorporated, and there's a whole ownership structure. The shares would be held. And then in 3.7.2.3, in terms of the proposed binding offer by Mshwayi, Mshwayi would acquire the business as a going concern for a purchase consideration of 225 million rand, comprising of all the items set out underneath that. The purchase price would be payable in cash on a debt-free basis. contemplated the settlement in full of creditors' post-commencement claims, balance to be distributed equally. And then in 3.7.2.5, which we highlight, the purchase consideration will be payable in cash, and there are the percentages. Initial payment will be on the terms to be agreed and will be held as a non-refundable deposit. The remaining 75% will be paid on the closing date of the proposed transaction or once all the approvals have been granted and all the conditions have been fulfilled. And then, Justice Nuku, in response to your question, an amount of 10 million rand in terms of this offer was being made available in addition to the purchase consideration for the transaction costs associated with the proposed transaction and the business rescue costs, including payment of a success fee. And so there were conditions, there were terms that were inserted that governed the situation with the working of the mine until such time as the conditions precedent would be satisfied, and so on and so on. Now, as we said earlier, Ndalamo, despite the provisions of its binding offer, is not and was never a creditor of Honor OPCO and could not vote. It didn't have any entitlement to vote, although the largest part of the PCF funding that it was making available and that was voted on by the body of creditors related to PCF funding. In section, bear with me, just to close off that point, as to the costs of section 144.3F. In terms of section 135, which Mr. Botha referred to, Justice Nuku asked questions about how the costs, the ongoing costs in business rescue are to be dealt with. And we just want to highlight in that regard section 135, subsection 3, which provides that after payment of the practitioner's remuneration and expenses referred to in section 143, and then we highlight, and other claims arising out of the costs of the business rescue proceedings, all claims contemplated in subsection 1, which is the employee's post-commencement claims, will be treated equally but will have preference over all claims in subsection 2, and then irrespective of whether they're secured or not. And then in 135.3b, in subsection 2, will have preference in the order in which they were incurred over all unsecured claims of the company. So what occurs is there is a super preference also conferred in terms of section 135.3 on the ongoing costs of administration and the affairs of the company in business rescue, which is why Mr. Botha and we submit that those claims also cannot be voted. Bear with me, Madam Presiding Justice. I am, Madam Presiding Justice, unless there are questions, I am not going to address any further topics.
Thank you, Mr. Mills.
Mr. Mills, are you suggesting that the claim then by Mashwai would be one that would be treated as cost of the business rescue proceedings? Is that?
Well, to the extent that it qualifies as such a cost, of course. It's post-commencement. Whether it's a finance claim, I know Mr. Botha didn't argue this too hard, but whether it's a finance claim or whether it's a cost of business rescue incurred by the business rescue practitioner post-commencement, it's treated in that manner. It's not voted. But it does enjoy a super preference. If not as a funding one, then even on a higher level after the initial costs are being paid under section 135.3.
Thank you.
Thank you, Justice.
Mr. Mills?
Thank you.
Thank you.
when I was here last and I got to the end of my 10 minutes and I hadn't been asked a question, I said to the Chief Justice that I hadn't been asked any questions, and he said, Mr. Mills, don't look a gift horse in the mouth. So, thank you.
Ritz? Simos.
Thank you, Justices, for Mashwai. I don't intend to repeat our heads of argument, go through them, we stand by them. I intend to raise certain topics, particularly taking a lead from questions that were put to Mr. Botha, which I intend to address certain of them. We also fully align ourselves with the heads of argument submitted on behalf of the Business Rescue Practitioner and on it in Business Rescue, where the interpretive exercise is dealt with extensively, as well as the question of foreign legislation. So I'm not trying to duck or avoid answering questions if they get put to me, because of course we've dealt with a wide range of aspects, but as discussed with Justice Chandra before the commencement, we'll do a division of work to avoid unnecessary repetition and to save time. The last question that was asked by Justice Nuku and was answered with regard to how will Mashwai's claim be dealt with? Just to say, well, that's a cost. That may be a cost in business rescue, and therefore it will be dealt with on the basis of a preference. But of course, it's not for Ndalama to say, it's for the business rescue practitioner to say. And that's the difficulty which is faced. There's no acknowledgement that Mashwai's claim is a claim which is going to be paid as part of the costs of business rescue. And one difficulty that we can identify in the approach by Westcol, Mr. Botha, is that the argument was devoted to dealing with the position of a PCF creditor and why a PCF creditor shouldn't have a vote. Now, Mashwai's position has always been, it contended in its affidavit it's a PCF creditor. The business rescue practitioner didn't agree with that. And we've consistently adopted the attitude since then, because it's a dispute on the papers and it's not something which the court is called upon to determine, as between the BRP and Mashwai, what the status of its claim is. What is common cause is that it's a post-commencement claim. Its seeded claims, which are some 39 million, which are also not contested, are pre-commencement claims. So Mashwai has pre-commencement claims, which it took cession from other people who held pre-commencement claims of 39 million, and 43 million, which is the post-commencement claim, the lease, the Quattro lease claim. Both those claims were recognized by the BRP, and they're not in dispute for purposes of these proceedings. The attack on those was abandoned in both courts before this. So, with respect, we have this conundrum that our learned friend, relying in particular on Section 135 and the fact that a post-commencement funder is referred to as a lender and not as a creditor, said, well, that indicates that PCF lenders are not creditors for purposes of Chapter 6. It was the argument up to today. For purpose of Chapter 6, PCF creditors are not creditors in any respect, in any section in Chapter 6. That's been the argument before today. Now, today we hear for the first time with respect, and you can look at the heads of argument, a complete paradigm shift, that PCF creditors are creditors for every purpose except for Section 141. Because of course, the absurdity and the tension which it would otherwise create, which is one of the aspects we highlighted in the SCA. But of course, he then, because he pegs the PCF distinction on 135, he's got nothing to hang the distinction for a post-commencement non-PCF creditor on. In other words, post-commencement non-PCF. And with respect, the question was asked by, I believe, Justice Matopo and Justice Majid raised questions in the context of how does someone who is a pre-commencement creditor, how can they also become a post-commencement creditor? And might I directly go to the issue with regard to the plan and show you how that could come about. because it's an aspect which was debated at length in oral argument in the SCA, but hasn't found its way into the heads because we didn't regard it as particularly relevant until we heard today's argument. But the position is the following, is that our learned friends seem to suggest that if you were to find that post-commencement creditors, whether PCF or non-PCF post-commencement creditors, don't have a vote, then it follows that the vote would have been carried and the plan would have been adopted. But as correctly read out by my learned friend from his own heads of argument, Mr. Miltz, what was common cause? Because I was there. I wasn't there at the leave to appeal. And of course, that's why that reservation was expressed by counsel who took my place because I wasn't available. Was that what was common cause is that if you take out Mshwai's vote, and only Mshwai's vote, the vote would have been carried. It was never common cause that if you take out all PCF, the vote would have been carried. The question is that if all the votes are counted except Mshwai, and that's in fact how the heads of argument have formulated it. If Mshwai's vote is not counted, the vote would have been carried. But let me now then cut straight to the chase. If we go to the plan which was put up for voting, and we have the conundrum that the plan was a plan drawn on the basis that post-commencement finance creditors had a vote. It was put to the vote on the basis, and it was a term of the plan, that they would have a vote. It was a term of the plan that post-commencement creditors' claims would be unenforceable after the implementation of the plan. Not in line with 154.2, which only says pre-commencement. The plan says post-commencement creditors' claims are also compromised and unenforceable. And what was the trade-off for that? We'll give you a vote, but if the plan is passed, you lose your claim except as covered by the plan. So now we have the difficulty, and with respect, that's why an order confirming the adoption of the plan could never be sustainable. Even if post-commencement creditors do not have a vote, the plan cannot be regarded as having been passed, because it self-destructs if you take out a right which the plan gives to post-commencement creditors to vote and say in law they must be excluded. Well, then the plan can't be regarded as adopted because its core value, the trade-off in the plan, is destroyed. So if we go to the plan, and I just wish to run through, it starts at volume 7 of the record, page 705. It's dated 14 July, and this is the plan that was put to the vote. You'll see at page 708, and please ask me to slow down if necessary, but I'm trying to give as many references as I can. Page 708, there's an identification of Annexure B, list of creditors and voting interest. Then 710, 1.3.11, business rescue is defined. And then 1.3.15 is an important definition which says claims. Claims means any claim of whatsoever nature and howsoever arising, including, but not limited to, secured, preferent, or concurrent claims that is envisaged in terms of the Insolvency Act, as well as an actual, contingent, prospective, unconditional, conditional, liquidated or unliquidated, assessed or unassessed claim, whether due or yet to fall due for payment. And then I stress, whether its origin arose before the commencement date from statute, regulation, or other legislation, or arising out of any contract and agreement entered into before commencement date, and then, important, or arising from any other cause of action whatsoever. So claims include the post-commencement claims, by definition. The post-commencement claims are in the definition. It starts off, any claim of whatsoever nature, including but not limited to, then ends off with the words, or arising from any other cause of action. Then we have commencement date, is 10 October 2022, defined at 7 and 11. Concurrent claim means any claim which is unsecured and enjoys no preference, and concurrent creditor has a corresponding meaning. That would mean, of course, that Mshwai is a concurrent creditor by definition. Then 1.3.2.5 at 712. Creditors means all persons, including legal entities and natural persons, having claims as defined, accepted as such by the BRP, as at the commencement date, and for the period of business rescue. And business rescue, of course, only commences at the commencement date. So it's claims as at the commencement date, that's pre-commencement claims. And it says, and for the period of business rescue. That means from the commencement date onwards. So creditors are defined as including the post-commencement creditors for purposes of this plan that was put to the vote. Then 715, 1.3.58 defines post-commencement claims, post-commencement creditors, pre-commencement claims, pre-commencement creditors. And then 7.717, 1.3.77. Unenforceable means that all claims, again as defined, will upon the adoption and implementation of the business rescue plan become unenforceable against the company as envisaged in section 154, and I stress, and stroke or as read with section 152. So in terms of 154, and or as read with section 152. So let's give meaning to that. Section 154, 1 says in 154.1, the plan may provide that if a creditor accedes to the discharge of his debt, then the debt is discharged. 154.2 says if a business rescue plan is approved, then pre-commencement creditors can't enforce their claims. But then what do we also have? It says and or, read with section 152. Now we have 152 sub 4, which says a business rescue plan that has been adopted is binding on the company and on each of the creditors of the company, whether or not such a person was present at the meeting or voted in favor of the adoption. So this is now providing that apart from limiting it to pre-commencement creditors under 154 sub 2, read it with 152 as well, in terms of this plan, all claims become unenforceable, and by definition including post-commencement claims. Then we then go to the other important part. We'll see that that's in the next volume. That's volume 8. Just give me a moment. Volume 8. No, that's volume 9. Sorry, I have volume 8 here. Yes. Sorry, volume 8. And I'm going to highlight something because I'm going to answer the question, how can a pre-commencement creditor become a post-commencement creditor? If we go in the plan itself, at 737, in the heading legal, paragraph 7.4. It says in 7.4.2.2 at 737, volume 8, the BRP has not, as at the publication date, cancelled any contract, but reserves the right to do so. 7.4.2.3. On the other hand, it should be noted that on 20 March 2023, Boipelo Mining Contractors informed the company of his intention to terminate the underground mining contract between BMC and the company with immediate effect. An interim arrangement was put in place, same terms and conditions, while BMC and the company negotiated a new mining contract. The negotiations between BMC and the company are still underway, and as of the date of publication, the negotiations have not been concluded. So, let's have a look what happened with Boipelo Mining. Boipelo Mining, if I ask you to go to volume 5, page 499, you'll have the list of creditors, which was the Annexure B. This is the Annexure B, which was updated a day or two before the vote took place, but this was the Annexure B at the time. So if we look at Annexure B, you will see, and hopefully the court has a A3 size page. You'll see on the left-hand side, it goes alphabetically, Boipelo Mining, pre-business rescue, 49, I'm just rounding it off, 49.9 million, post-business rescue, 50.8 million. Total, 100 million. So its pre- and post-commencement claim, according to this schedule, is 100 million. Now, if I go to volume 8, yes. There was an audit done with regard to how people had voted, and that audit report is PLM 13. It's in the same volume 8, and I want you to go, if you may, Justices, to page 806. Now, option B is the Indulamo offer, which they want to have declared to have been validly passed. You'll see in 806, Boipelo Mining, number 2, voted in favour, 96.4 million rand, 27% vote. That includes its post-commencement vote. That's one example. I can give a lot of other examples. All the post-commencement, according to that list, we tally them all here. You'll see all the post-commencement creditors in Schedule B voted one way or the other. But here's one who voted a 27% vote, and let's assume half of it was pre-commencement and half is post-commencement. 13.5% was voted in favour of Plan B, option B, on a post-commencement vote. Those are the aspects that I pointed out to the Supreme Court of Appeal when we said it would be advanced, and counsel in my place said evidence would be presented, but the evidence was already there. So I didn't need to present other evidence. The evidence is already here. It's uncontrovertible. There's no dispute about how the people voted. So post-commencement claims of other people were voted. The common cause fact is if you take Mashwai out, the vote would have been carried. But it was never, and it's never even postulated on that basis, if you take all post-commencement creditors' votes out, the vote would have been carried. So we go back to what the plan provides. So Boipelo, which is a big one, voted in favour on a post-commencement claim. Then 747, trading activities following the commencement date. 8.3, both management and the BRP have continuously engaged with employees and critical suppliers, all of whom express support for the company. This is demonstrated largely by the fact that service providers and other suppliers continuing providing goods and services on the same terms and conditions that existed before the commencement of business rescue proceedings. They're not PCF creditors, they are just post-commencement creditors, not funders, not lenders, not post-commencement financiers. On the face of the description, they're post-commencement creditors, but not PCF. And then 748, because remember section 150 says what the plan must set out. One of the things the plan must set out, the creditors of the company as at the commencement date, you found that at 748. Then it says, a list of the creditors as reflected in the company's records as at the commencement date is attached here to marked Annexure B. Now if you look at Annexure B, it has a column pre-commencement, so that shows you who were the ones at the commencement date. You take what is the pre-commencement amount, and that tells you those creditors were the creditors at commencement. Then there's a column which shows post-commencement. So Schedule B not only shows the pre-commencement creditors, but also shows the post-commencement creditors. It does both. And the question was posed, well, can you give more information than Section 150 requires? My learned friend correctly said, of course, you give as much information as you think is relevant. So Schedule B gave information of pre-commencement and post-commencement. Then it says, as required in the Act, Annexure B indicates 10.2.3, the creditor's voting interest determined and calculated in terms of the Companies Act according to the claim amount approved by the BRP. If you look at that Annexure B, the percentage vote amounts which are allocated are a combination of the pre- and post-commencement claims, aggregated as part of the total liabilities, and the voting percentage is allocated on that basis. So this plan says your voting percentage is allocated on the basis of claims approved by the BRP, including post-commencement claims, and your voting percentage has been determined on that basis. And that's what was put to the vote. Now what the applicants want to happen, and they wanted in the court or quote to happen, was that exclude the right of these people to vote, although the plan expressly gives them the right. What about the parts of the plan that says their claims are then unenforceable, but they're now not allowed to vote? In other words, they must suffer the consequence of their vote being excluded when they went into this plan on the basis their vote would be counted. And also significant, on the record, there's no indication that Westcol or Ndulamo objected at the meeting to the allocation of votes to post-commencement creditors. So everyone acquiesced and went to the meeting on the basis of this plan, that votes were being given. So, page 750, creditors' voting interest, paragraph 11. In terms of the Companies Act, and for purposes of any vote by creditors, 11.1.1, a creditor recognized with a claim in Annexure B, and of course there are two categories, pre and post, has a voting interest equal to the value of the amount owed to that creditor by the company as reflected in Annexure B. And then it talks about 11.1.2, a creditor who would have a subordinated claim in liquidation has a voting interest, etc., etc. Now, just as an aside, what is a subordinated claim in liquidation? In matter of Vantage Goldfields versus Arkamanzi, I don't out of my head have the reference, but there were two matters of Vantage Goldfields with Arkamanzi, SCA judgments. I was involved in both matters. In that, the court dealt in the second judgment, both reported. In the second judgment, dealt with the position of a subordinated claim. That was a shareholder who said, I subordinate my claim to claims of all other creditors. In other words, I put myself at the end of the queue. That's what it means. Subordinated in liquidation, by agreement with the company, I'll give up any rights I have in favor of all other creditors. So that's a subordinated claim in liquidation. It ranks last. So a creditor with a claim, 11.3, a creditor with a claim for PCF will have a voting interest in the business rescue of the company for the amount owed by the company to that creditor. It's part of the plan. Then, (23.1) at 775. Once the distribution is made to creditors, all claims against the company will become unenforceable. For the avoidance of doubt upon payment of the distribution, all claims against the company will become unenforceable against the company in terms of section 154, read with 152 sub 4. And I've read 152 sub 4. It says every creditor is bound by the adopted plan. Every creditor, for purpose of this, they vote on the basis and they become bound. If they bond, they become bound to a plan which says even post-commencement creditors are bound and their claims become unenforceable other than provided for in the plan. Now, audit of distribution, page 778, paragraph 27. You'll see the waterfall, secured PCF creditors, unsecured PCF creditors, and unsecured concurrent creditors. So interesting, you've got secured PCF, because they hold security, they must come first, unsecured PCF, then unsecured concurrent creditors. That, of course, is post-commencement creditors who are not PCF, is included in concurrent creditors. And then, yes, I believe that wraps up the reference to the plan. So, with respect to wrap up, we have on that, we have with respect the tension and the dichotomy that is created, is that there's a plan which said everyone has a vote. These are your voting percentages. Now, the court is asked to find that in terms of the Act, no one had a vote. But does that mean you can't give them a vote in terms of a plan if everyone agrees to it and if no one complains? If they were given a vote in terms of the plan, then the plan wasn't passed. That's common cause. If all the votes are counted and correctly counted, it's common cause. The plan was not adopted. If you take just Meshwai out, it was passed. But what about Boipelo? Where's the calculation? Boipelo's not the only one. The exercise is just a matter of going to one page, going to another page, adding them up, taking them off. It's an arithmetic exercise. Now, if I might move to answering certain questions. our key submission with regard to Chapter 6 is that creditor must have the same meaning throughout Chapter 6. Our learned friends, as we understood them up to today, have actually agreed with us, creditor must have the same meaning throughout Chapter 6, but except the meaning must be excluding post-commencement finance or post-commencement creditors. Now we're on the same page. Creditors has the same meaning except for Section 141, and in Section 141 it must exclude PCF creditors, we heard, but we didn't hear that it must exclude post-commencement creditors. So we still don't know what the contention is. What does creditors mean in 141? Because the argument that PCF creditors go into it willingly. They know what they're letting themselves in for. They're putting their skin in the game. Now, Boipelo is an example of someone who voluntarily became a post-commencement creditor by continuing to render services. If one wonders whether they continue to render services, there's a subsequent plan which is published on the 11th of August. That records expressly that the plan I gave you said they're busy negotiating. 2 weeks later, the amended plan, which was never put to the vote, records that they have agreed to continue to provide services on the same terms and conditions. That's why they had the two claims. Two claims had already originated, but it was going to be an ongoing basis where the post-commencement claim would continue to increase. So, our submission is that consistent meaning throughout for creditor, creditor means creditor. Now we've got, my learned friend said, oh no, but a PCF creditor can protect itself because it can participate in the plan. And that's of course where the concession had to come, that creditor for purposes of Section 150 must include a PCF creditor, because otherwise they can't participate in drawing the plan. Because Section 150 provides for a plan to be drawn, provides for the plan to be drawn, and it must be and the right to participate, proposal for a business rescue plan, practitioner must, after consultation with the creditors. And my learned friend must have it, of course. That means must consult with the PCF creditor. And then meeting, 151. The practitioner must convene and preside over a meeting of creditors, not affected persons. It says creditors and other holders of voting interest. So creditors and other holders of voting interest, which of course would be shareholders. And then consideration of the business rescue plan at a meeting convened in terms of 151. So if creditors for purposes of 151 includes a post-commencement finance creditor, then at 152, it also includes a post-commencement finance creditor, because it says at a meeting convened in terms of Section 151, the practitioner must introduce the proposed business plan for consideration by the creditors. It can only be the same creditors to whom notice was given under Section 151. And then they're allowed to vote. But now my learned friend says, no, PCFs must be given notice. They can participate, but they just can't vote. So the argument seems to us to be that because PCF creditors or post-commencement creditors are not expressly included in creditor, they must be regarded as excluded. Our core argument on interpretation is really inclusivity is intended, the broadest participation of affected persons and creditors, and no one is excluded unless they're expressly excluded. Not no one is included unless they're expressly included, which seems to be the applicant's argument. Just to touch on the difference between insolvency and creditors, creditors in insolvency, creditors under business rescue. There's an important aspect to bear in mind, that on a liquidation of a company might be liquidated on the 1st of June. The application was instituted on the 1st of February. When the order is granted on the 1st of June, the liquidation is deemed to have commenced on the 1st of February when the application was lodged. So what you have when the application was lodged, there were creditors. That's when it's deemed to commence. But when the winding up order is granted on the 1st of June, in the interim, more creditors have joined. In liquidation, the concursus is not the creditors at the deemed date of commencement, it's the creditors on the date of the winding up order. So there you have post-commencement creditors in liquidation who have a vote. In a company, post-commencement creditors have a vote. If they're post-commencement but pre-winding up order, they have a vote because of the deemed retrospective commencement. So it's not a good analogy to say, oh, concursus creditorum, they don't have a vote, they do have a vote. It's not comparing apples with apples. Yes, and then just,
Your time is up.
yes, can I just make, yes, one last submission on the aspect that my learned friend, Mr. Botha, talked about. A post-commencement creditor can always have control over the content of the plan. But that presupposes that he becomes a post-commencement creditor after the plan is adopted. Because let's think it through. If he says, I'm prepared to give money, well, he hasn't given money yet, so he's not a post-commencement creditor. So he can't go to the meeting. He's not given notice of the 150 meeting. He can't participate in terms of 151 because he's not a creditor on any definition. So he can't have any influence in the plan. He can't go to the meeting and try to persuade people of anything. Then the plan is adopted. What control does he have over the content of the plan? If, of course, he hasn't given the money yet, and he says, I get someone else to put forward my plan, like Ndulamo, not a creditor. I get someone else to put forward my plan, or I put forward my plan to the BRP. If that plan is voted in, then I'm prepared to provide finance. Then they've got control, because if their plan doesn't come in, they don't provide the finance. So, of course, the argument doesn't deal with the person who gives post-commencement finance before the plan is prepared and adopted. So with respect, I believe that that deals in essence with the core of what I wish to advance. Of course, there's a lot to be said on interpretation, but I'm open for questions on the whole range of the case insofar as is necessary.
Mr. Maritz, the Act seems to contemplate that creditors in a business rescue proceeding will file claims for proof at the first meeting of creditors. That, in this case or in general, do creditors whose claims arise after the commencement of business rescue submit their claims to proof?
Well, Justice Rogers...
Just can I ask, is there evidence in this case that any of them did?
Yes, well, Justice Rogers, I'm not sure that the Act contemplates the same procedure or a procedure akin to insolvency where you submit claims for proof. But I may have missed it, but I'm not sure whether it requires the submission of claims.
Well, Section 147(1) says, within 10 business days after being appointed, the practitioner must convene and preside over a first meeting of creditors.
Yes.
Which, among other things, the practitioner may receive
proof of claims
by creditors.
Thank you. Yes, that section. So it doesn't have the strict procedure on insolvency that there must be affidavits, etc., but there is a meeting for that purpose.
If proof of claims applied to post-commencement creditors, they might be changing every day.
Yes, up to the date of the vote.
What would be fixed and settled would be the claims of people at the commencement of the business rescue. But the claims of people whose claims arise after the commencement would be a moving target.
It would be, correct. And might I immediately say, Schedule B did change for that very reason. Yeah.
So the claim that a post-commencement creditor has on the day of the meeting when a plan is voted upon may be more or less than the claim he had on the day before the meeting.
If I give you...
It depends, for example, did a landlord's rent for the next month
okay, no.
due?
I just wanted to be sure I got the question. The answer must be yes. So, in fact, if money became due today it wasn't due yesterday. My claim yesterday was maybe 100,000, today it might be 150,000.
So notionally, on your argument, the post-commencement creditor can say at the beginning of the meeting, just by the way, I'm a bank, another month's interest has fallen due, so my interest must go up by a certain amount. And the practitioner may say to a supplier, well, yesterday afternoon I paid for some of the stock you supplied me, your claim must go down. It all has to be worked out almost on the fly.
No, but with respect in the circular, my learned junior might find, but in the circular there was a specific provision made that people who have now received notice, which would have had the schedule with the plan adopts, must by a cut-off date, which was before the meeting, raise any issues they have with regard to claims.
But it may be difficult to do it because the line isn't drawn until effectively the moment that the votes are cast.
No, with respect, the line is drawn before the meeting because it proposes for a cut-off date before the meeting.
So a post-commencement creditor whose claim might have been substantially settled on the day before the meeting gets to vote because 5 days before the meeting he was in the list of creditors.
Well, might I answer that? I would submit not because the BRP would know the claim is settled, but might I just answer the following. Leave about post-commencement creditors, a pre-commencement creditor whose claim may have been settled the day before the meeting. Would also then on that notion be entitled to vote, but that wouldn't be.
Well, I'm not sure that absent the adoption of the plan, the business rescue practitioner can start settling pre-commencement creditors. There's a moratorium on their claims. The Act doesn't appear to envisage that the quantum of the pre-commencement claims will change. They won't be diminished, and because they wouldn't include post-commencement claims, they wouldn't increase. I'm not saying it's a definitive objection, but the difficulty I have with the inclusion of post-commencement creditors is that it seems to be a moving feast. The Act appears to contemplate, for example, that within the creditors, for example, at a very early stage, they may vote on whether they approve the appointment of the business rescue practitioner. They may set up a creditors committee. They form views as to the way ahead. If all of those decisions are being made by the same constant body of pre-commencement creditors, there is coherence. But if pre-commencement creditors are included, as the post-commencement creditors are included, as their claims increase, they might begin to dwarf and outvote the pre-commencement creditors. And so they might say at one point, all right, now we want to convene another meeting and change the meeting of creditors. We've got different ideas about who the practitioner should be.
Yes, with respect, I agree that in theory, yes, the way the Act is structured, and unfortunately because it doesn't have specific provisions on this, it administratively creates a difficulty in administrative management, but it's not insurmountable because in this case it was shown not to be insurmountable. There wasn't, in fact, this case has not been about anyone objecting to someone being included who shouldn't have been included, except on the question of categorization.
With specific facts of this case, and there may well be cases where the sorts of objections I have raised wouldn't arise on the facts.
Yes.
But the interpretation is one which creates this constant state of flux as to who is the body of creditors.
Well, correct, it does. That is a factor. I must immediately say that is a factor to be taken into account as to whether post-commencement creditors are included or not.
Section 151(2)(c says that at least 5 days before the meeting, that's when the plan is to be considered, the practitioner must deliver a notice, and C says a summary of the rights of affected persons to participate in and vote at the meeting. Now, that would include the creditors as affected persons.
Yes.
It appears to envisage that their rights to participate will be known in advance of the meeting. Now, even if it's only 5, there are a couple of possibilities. You might say to me, well, what that means is the line is drawn in the sand 5 days before the meeting, and changes, increases and decreases in post-commencement creditors' claims in that 5-day window is excluded.
Yes.
Or you might say, no, they still have to be adjusted if they change within the 5-day window.
With respect, again, either or the other, but let's look at what the plan provided. The plan provided for, as it were, this cut-off date, and there's a schedule. The plan provided for that. It was updated a couple of days before. Mshwai was one of the ones who complained and said it wasn't 5 days before, but that objection was dismissed by the court of Kwa. But this plan provided for people whose claim was not included and weren't there for the voting, had an opportunity and a procedure to have their claims recognized and added afterwards, after the plan had been adopted. There was provision for that.
If it is concerned, insofar as creditors are concerned, with pre-commencement creditors, then, and all of this is meant to be happening quite quickly. I know often the process takes longer than it should, but the
Yes.
intended process is a couple of months.
Yes,
And you
but in practice, a couple of years.
in practice a couple of years. The ideas may well be that all affected parties should be in a position to determine in advance of the meeting whether they have an objection to anybody being in or out, or the quantum of their interest. The movable feast argument, interpretation for the creditors, means that you may not even know the answer when you arrive at the meeting, and you may have no way of finding out.
Well, might I venture the answer? For every problem, there's hopefully a solution. If you read the 5 days notice beforehand, to be implicit in that is that, again, you can submit proof of your claims. And you ask me, was there proof of submission of claims? Yes, there is, because it's common cause that claims were verified or considered by the BRP and were accepted and were included on the list. So at least there's circumstantial proof that claims were submitted, considered, and accepted. So to then interpret Section 150 together with the problem that has been raised on the basis that the line can be drawn then 5 days beforehand, because you've got to give them 5 days notice. If your claim is not there 5 days before, then because you didn't submit your claim, you might not be allowed to vote because you didn't put your hand up, but you're not locked out because the plan provides that you can still bring your claim.
Well, the post-commencement creditors may be on the list not because any of them submitted claims for proof, but because the practitioner in running the business just has them on his list of people to whom he's run up debt.
Yes, but Justice Rogers, one of the points that we did make, we submitted that, having regard to the structure of Chapter 6, that it's the performance of an administrative power given to the business rescue practitioner to determine what claims he accepts and to allocate the voting rights according to the hierarchy and the calculation. And one thing we know here, there's no dispute about what claims he accepted and what claims he put on the list. And that was never changed.
As a practical example of the moving feast, although it may not
Yes.
have made a big difference in numbers, as I understand the Mashwai Quattro contract, its claim would have been reducing day by day as it got more performance in return for the upfront fee it paid. So its claim would never be fixed on a certain date. It would, by in the nature of things, be diminishing day by day.
Yes, on Mashwai's claim, its claim on the record was formulated on the basis the unutilized portion of the prepaid rental.
Yes.
Yes.
A final question, not entirely facetiously, may the practitioner vote as a creditor? Because under Section 143, there's a claim due to him by the company for his remuneration.
But it's not due and payable.
Well, is it not due and does it have to be due and payable to be a creditor?
Well, let me put it this way. If his claim has been approved, then on our argument, conceivably, he'd fall within the category of creditors. But if he has an agreement, a remuneration agreement, which is normal per hour, then of course he first would have to submit his claim. His claim would have to be verified, and he doesn't have a claim before then. It's the same as his claim has to be assessed in terms of the contract. He can't just put up his hand and say, I have a claim.
It seems to me that the practitioner is lumped together with certain other parties in Section 135 as special cases. There are the employees in respect of their remuneration post-commencement.
Yes.
They don't get to vote on it,
Yeah.
not creditors for that, but they have a super preference.
Yes.
They're the interests of the post-commencement financiers, and then there is the business practitioner in respect of his remuneration and the costs of the business rescue. Now, I personally take the costs of the business rescue to be the ordinary trade people who have continued dealing with the company during business rescue, supplying it. That's the cost of keeping the company going. All of those people are dealt with under Section 135, including the practitioner.
Yes, thank you for pointing that, because I think that might be the answer on the practitioner.
So
His guaranteed payment.
So the people who get paid absolutely first are the practitioner and those people whose claims are part of the costs of the business rescue. The people who then have preferences are the employees with their super preference and the post-commencement financiers. So that would accommodate everybody who could notionally be a post-commencement creditor, including the practitioner. They have their own regime with preferences. And as I say, that they change from day to day. What doesn't change from day to day, and on the face of it constitutes the body of creditors, are the pre-commencement creditors.
Yes, the pre-commencement creditors are pegged in time. The employees after commencement, the BRP, the costs of administration, the costs of keeping the mine open, they would be costs in business rescue of keeping the operation going.
Just explain why you thought Section 135 would be an answer to my earlier question as to whether the practitioner is a creditor who can vote on them. Assuming he...
No, I didn't think Section... I misspoke then. I didn't mean Section 135. Section 135 only because of the order of preference. It gives preference to his claim. So not because there's a specific provision as to what category his claim falls in. But also if you look at the Schedule B, the business rescue practitioner didn't put his own claim in there. So he himself chose to, insofar as he might have had a vote, he didn't give himself a vote because he didn't put his claim in.
No, but we just do need to consider whether we are going to say that every person who has a claim against the company at the date of the meeting is entitled to vote. Then we would either have to say that for some reason, on a proper interpretation, that doesn't include the practitioner, or we might have to say it does, or we have to say the question isn't germane to the outcome of this
Absolutely.
case.
No.
In principle, if it's an unqualified creditor, it ought to include the practitioner.
Well, in principle, if there's an amount which is in fact can be established as being owing, in principle, unless there's a reason to say he's in a special category. And might I just take up on that? It does, because from a Schwei's point of view, it mattered not whether for purposes of this argument and in the previous hearings, it was a post-commencement finance or a post-commencement creditor. Yes, but of course, there's more to be said for the applicant's argument that PCF is excluded than is to be said for post-commencement concurrent creditors are excluded. I want to put that down. There's more to be said for the argument because they latch on to 135, etc., and because of the security given to post-commencement finance creditors. Post-commencement non-PCF creditors are concurrent creditors that stand at the end. Why shouldn't they have a vote?
As far as every post-commencement creditor who's not a post-commencement financier or an employee seems to me to be a person who has a claim in the course of, as a cost of the business rescue. They stand in front even of the financier.
No, but
what gets paid first is the business rescue practitioner and those persons whose claims arise as a cost of the business rescue. The employees and the financiers come after.
No, Marta ventured an example which we gave in our heads of argument. And again, I don't want to give evidence, but it's a practical example, came from a case I was also involved in. But it comes with the following. A mine hires what they colloquially call yellow equipment from a supplier of mining equipment. The mine operates it. At the date of business rescue, there's R1 million owing for the rates that have to be paid and is not paid. So business rescue commences, and it's a pre-commencement creditor for R1 million. But the mine keeps the machinery. It doesn't necessarily use it, but it doesn't return it. There's the machinery sitting on the mine, doesn't want anyone to touch it. The mine's operating or not operating, but doesn't get paid. It's a post-commencement creditor, but an unwilling post-commencement creditor. And that post-commencement claim doesn't have anything to do with the costs of the business rescue. It's a consequence of the conduct of the business rescue practitioner who might or might not return it, or might not, if he cancels the contract, if he chooses to cancel the contract, he can give the equipment back. He chooses not to cancel the contract, doesn't use the equipment, but doesn't pay for it. Then, of course, that's an unwilling post-commencement creditor who's not a PCF creditor. And there's no place for them on my learned friend's argument. And with respect, that's a conundrum.
Yes, I haven't thought through that. It could happen in a liquidation as well.
It could.
And as I understand it, in the liquidation or insolvency scenario, the liquidator might elect to perform or effectively breach.
But the specific
executory contracts, and if he breaches the executory contract, the creditor will have a concurrent claim for damages, but it'll still be in the concursus, even though theoretically the claim arises because of post-liquidation action by the liquidator.
But fortunately, in the insolvency law, there are specific provisions from 1936, which have been trashed out in hundreds of judgments. But here we sit with legislation which everyone says it's a shoddy piece of draftsmanship. Many judges have said that in many judgments. And we can't say anything. It certainly asks more questions than it answers, in my view.
Well, it would have saved us the trouble if they'd been clearer, but it would have then deprived you of a brief.
Yeah, thank you, thank you. Thank you, Judge. I welcome the interaction on these issues. Thank you.
Mr. Maritz, I have two questions. One flows from what you'd argued, and the other one from something I'd raised earlier with Mr. Botha. Just about your argument about, you've gone to great lengths to show us in the record the position of Bopelo Mining. And the point I take from that is that even if this court was to uphold the High Court's interpretation, then the outcome must be that the matter must be remitted for another vote by creditors. Is that your argument?
That's my submission, yes. And not only for that reason, but for other reasons that the SCA might have given, but with respect, it struck us that another reason. And the reason it wasn't, although it was argued in the SCA, wasn't dealt with, was because they made the finding on the interpretation and it became unnecessary.
Yes, of course, I understand that.
Thank you, Justice.
I just wanted to make sure that we're on the same page.
Yes.
Now, and Master, can I just say this? This wasn't dealt with by the other counsel for the applicants. But can I just say, prima facie, especially if you take somebody like Bopelo Mining with a 27% voting percentage, and on the assumption that half of it is pre-commencement, half post-commencement, it does prima facie seem to me to be so. That is if we are with the applicants on the interpretation. But let me get to the question I asked Mr. Botha. As I said to him, this legislative history is quite illuminating, but should we have regard to it? And if not, why not?
Well, with respect...
The history in their supplementary affidavit in this court.
Yes. Well, with respect, we didn't oppose, we were silent on that, and that's because we knew that the other respondents were opposing. But with respect, we submit that with regard to legislative history, you shouldn't take cognizance of it, because if we look at the legislative history and the debates, these issues that are in the fore now, we're not outside the mind of those in the history. But they chose to draw the act as they drew it. And with respect, we also, with regard to foreign law, we briefly on foreign law, we must say, the fact that there's a definition of a creditor in the United States legislation doesn't mean, in absent a definition here, you must import that definition. Our courts have been more ready to consult foreign jurisprudence in matters such as rights which are attaching to persons and property which aren't defined by statute. In other words, well, how far does the right to privacy go? What do we do about the death sentence? What do other jurisdictions do about that? Is that a cruel and inhuman punishment? This court considered, of course, other jurisdictions. But that's in a different realm to where you have statutory regimes which define creditor, which expressly define voting rights for certain categories. One can't just say, because they did it and we didn't do it, therefore you must read it into our act on a simplistic level. I know it's more complicated than that, my learned friend argument, but in essence it seems to us what they're suggesting, and we submit that there's no room for that. Mr. Simon, I know, has dealt in his heads, with which we align ourselves at some length with regard to the resort to legislative history and legislation in other countries. Our legislative history doesn't favour either party, because the one argument would be, well, they considered all these things and they didn't make it express because they wanted the normal meaning to be the normal meaning.
Can I think I'm satisfied with the answer that you've given. That doesn't mean I'm persuaded, but
No.
answered the question. But can I just say on foreign law, I think it must be so that when one deals with commercial matters generally, but a statute like this, like the Companies Act that deals with business rescue, one should be slow to look at foreign law because it's a completely different scenario and different considerations, economic considerations, which infuse the Companies Act, but also legal considerations in a country like ours are at play. So that is my own position. So you need not go there.
Yes, might I just give
I was more concerned about the legislative history. Can I just say this?
Thank you.
If legislative history is an aid for interpretation, it must carry very, very little weight.
Very little weight.
Greater scheme of things.
Yeah. Very little weight, because one with respect, one must be very, very wary and loath to say, well, in the debate, they wanted to achieve this. But on a proper interpretation of the Act as it stands, they didn't achieve it. But now I'm going to read it in, although they chose not to write it. With respect, that would be a very high mountain to climb.
Mr. Marit,
Yes.
on this side.
Oh, sorry, Justice Matoko.
I need to ask you about two questions. The one is what the SCA alluded to. The section 7K and L, looking at the purpose
Yes.
and the application of the business rescue. Would it make business sense if one were to contend, as the applicants have done, to say we would have to exclude the post-commencement finance or post-commencement creditors, when the purpose of the Act, as I read from Section K, would say, to provide for the efficient rescue and recovery of financial distress companies in a manner that balances the rights and interests of all relevant stakeholders. Would relevant stakeholders include post-commencement financiers and creditors?
Well, with respect, my submission is it would. And might I also, in answering the question, it reminds me of an example that I gave in the SCA. Just bear with me a moment. Sorry, my lady, I've got a dizziness. I just need to take a breath. No, I don't have to adjourn. I just, in my mind.
Shouldn't we rather take a...
No, I'll do it now.
Are you fine? We could take it. We were going to adjourn for lunch, Mr. Marit.
No.
Mr. Marit, let's adjourn for lunch.
Okay,
It's
thank you.
1:30.
Thank you. I'll address that. There was an example that I gave to the SCA, which actually answers that question.
Yes. What adjourn? We take a 30-minute adjournment for lunch.
Now sometimes I get unsolicited tachycardia. Shit.
Just throws you.
Yeah.
You get dizzy and...
Yeah. It's transient. It takes about a minute. I had it about 10 minutes ago. I almost passed out. I was actually going to say to you, you stand up and ask for an adjournment.
I know, would it?
Yeah, no.
Shit. Sorry, that one went over me.
What is the question? With regard to section 7. Yeah, with regard to 7. With regard to... But I think... sorry, no, sorry. just make a note of that. Yeah, this is the thing. The point is the following.
Mr. Marutz? Is off, Mr. Marutz.
I apologize. What I postulated in answer to a similar question in the SCA, and we were dealing with the question of PCF creditors, who of course have a protection in terms of the hierarchy. They really can't be ousted by any plan, whether they're voting or not. But a post-commencement non-PCF creditor, I said, if one assumes that they're not a creditor for purposes of participation, they can't vote, then of course, under section 152.4, are they bound by a plan? Because the ones you're bound by the plan are a creditor. And of course, that must be the same creditor as the one who was allowed to participate in the vote. So on that argument being postulated there by the other side, if they're not a creditor for purposes of having a vote, and not a creditor for participating, then how can they be bound by the plan? And if they're not bound by the plan, then the plan gets implemented, and the day after the plan is implemented, that post-commencement creditor, who's not PCF and therefore has not been paid in the waterfall, delivers a section 345 notice to the company. Says, pay me within 30 days, don't pay me, apply for liquidation. And what was the purpose of the business rescue? Business rescue is supposed to bring an end to the financial distress. If you can't catch all the creditors in the ring, as it were, to sort out and clear the playing field, then you've got this type of creditor who, as we see on these papers, can be enormous, who's not catered for, not compromised, and of course has an unassailable claim the day after the plan is implemented. That is a problem which is created by saying creditor doesn't mean post-commencement creditors.
My second question relates to the voting rights.
Yes.
And what is defined in the interpretation. The voting rights, as according to the interpretation, means voting rights in respect of any member to be decided by a company means A, the rights of any holder of a company's securities to vote in connection with that matter in the case of a profit company. What I would want to know from you is the definition of a holder of a company security. Would that include both or exclude the other?
The definition, are you talking about voting rights in section 1 of the Act?
Yeah.
The rights of any holder of the company's securities. That company's securities referred to as shares. The holder of the shares in the company. A company's securities with respect in that definition means the shares in the company. In the old Companies Act, we talked about shares. They now talk about securities, and there's a securities register. It doesn't mean security over property on the face of it. So we're talking about shareholders then. The rights of any shareholder to vote in connection with that matter. The rights of a member in the case of a non-profit company, because in a profit company you have shareholders or holders of securities. In a non-profit company you have a member.
Lastly, the applicants contend that when you look at the architecture of the Act and the various sections that Mr. Botha took us through, says it excludes, yeah, I know I'm repeating, the word creditor would exclude the PCF or post-commencement creditor. Yeah. And your contention is that we should look at the business plan, which also includes the PCF and post-commencement creditor, and read that as meaning or as including the post-commencement creditor, and that because the Act or the Act did not specifically exclude it,
yes,
it is therefore included.
Yes, but might I just give a slight nuance just to put our position? Our position on the interpretation is that it's all creditors. But of course, our argument must stand on a bit of a weaker footing with a PCF creditor, because they might fall under 135 and have a specific protection. There might be some argument for them, but a post-commencement non-PCF creditor should be dealt with like all other creditors. But the relevance of the plan and what the plan contains on two legs, it shows that those who were running, the business rescue practitioner and the creditors, thought that this is the way the Act should be implemented. They were right or they were wrong. But assuming they're wrong, assuming none of the post-commencement of any category had a vote, then the fact that it was put in the plan as part and parcel of the plan means that that plan can never have been validly adopted, doesn't matter what the voting was. So I think that to make our, on the two legs, our position clear.
Excuse me. I wanted to understand your argument on Chapter 6. I mean, do I understand you to say that it gives the business rescue practitioner discretion as to who's going to have voting rights in respect of a plan?
No, not a discretion. He must make the determination.
So he makes a determination as...
Yeah. He can't decide, oh, I like you and I don't like you. It's not a discretion in that sense. In other words, it's an exercise of a power, because he's the only one who can determine who has the voting rights and what they have.
That power arises from where in the Act? Where do we find the power?
Well,
make that determination on which creditor is...
Let me find the section, section 1. Let me get it. I think it's in 150. I think I found something about that in 150. Complete list, proposal, the nature. Voting rights. I apologize for the moment. The rights of employees, the section dealing with voting rights. Proposal of meeting to determine. Sorry. Yes. Thank you. Sorry, it's in section 145, participation by creditors. It says each creditor is entitled to notice, etc. In addition to the rights, each creditor has the right to vote, to amend, etc., and so on. And then we get in sub 5, the practitioner of a company must determine whether a creditor is independent for purpose of the chapter. Request a suitably qualified person to independently and expertly appraise and value an interest contemplated in, that's an interest if it's a subordinated claim, give written notice of the determination or appraisal and valuation to the person concerned at least 15 days before the date of the meeting.
So the power is in sub 5, you said?
Yes, and it's
that
also...
determine whether the creditor is independent.
Yes, but then also, the question of, he's the person in control of the development of the plan and of the voting on the plan. And of course, he has to give notice of the meeting, and again, one has to have a purpose of reading. He's the person put in charge. Someone has to tell the people who's voting and what their votes are, because otherwise we can have a situation, it can only be the BRP.
But then he'd have the power to say that he can vote.
Well, again, the question whether, yes, and again, read with section 147, I'm assisted by my learned friend, thank you, 147 sub 1 sub 1A, the practitioner at this first meeting may receive proof of claims by creditors. So, of course, if he's going to receive them, someone must evaluate them. There's a lacuna to say who must evaluate them. In insolvency proceedings, for example, you have the magistrate or whatever at the meeting will either say, I accept or I don't accept. and it will be recorded in the minute. There isn't a
As
procedure.
Judge Rogers canvassed with you, that's difficult in post-commencement credit, in the situation of a post-commencement creditor.
Yeah.
In the sense of to evaluate the claims at that stage is a moving target.
Yeah. It is a moving target, yeah.
So when I'm just trying to understand, if he has the power to determine which creditors may vote, then he has the power to determine, the only power that he doesn't have is to determine that employees in a post-commencement situation, they cannot vote because of the Act.
Yes, the Act excludes their right to vote.
So they're the only category of post-commencement creditor that's excluded.
They're expressly excluded.
It includes then, on your version, on your own take of the legislation, includes the power to make a determination that he can vote, that post-commencement creditors can vote, that post-commencement financiers can vote.
Well, let me put the answer is with respect, not quite that. I gave that impression, it's otherwise. If on a proper interpretation of the Act, all creditors are covered by the term creditors, then the answer is yes. But if on a proper interpretation, creditors only means pre-commencement, he has no power to add creditors which the Act doesn't contemplate. In other words, he can't expand by his conduct. He doesn't have the power to expand the definition. The definition must be, and the interpretation must be what the legal interpretation is. So we're not suggesting that by putting it in the plan, he gave people a right which the Act didn't give them. Our submission is that he gave effect in the plan to the rights which the Act on a proper interpretation does give. And insofar as they didn't have those rights, then the premise of the plan was, these are the people who are voting, these are their voting interests, come and vote for these plans. And at the end of the day, then it turns out just to be a farce, because those people never had voting rights, and you can't give them voting rights they don't have. And therefore, what was this all about? It was a non-issue. It was an election where all the voters weren't registered.
Is it open to this court, if it were not to be with you,
Yes.
to say that one can ignore the vote of your client and that the matter then gets referred back, that its vote is a nullity? What would you see as the appropriate remedy?
No, what the appropriate remedy, which was, let me come back, which was debated, was that if the court finds that post-commencement creditors can't vote, remember my client has two categories, succession, which is not in contest, which is about 39 million. They were pre-commencement creditors. So I'm talking about the quattro vote, the 43 million.
Yes.
Then with respect, and that was, I know, debated in the SCA, was that the court should, if the court's determination is that no post-commencement creditors in any category, PCF or otherwise, have a vote, then it must be sent back for a voting where only the pre-commencement creditors can vote, and everyone who had a post-commencement claim must be eliminated from the voting. Not just Mshwai, everyone with a post-commencement. Can't only eliminate Mshwai, must then eliminate all post-commencement creditors.
So there's no way of preventing the plan and the voting on the plan from self-destructing if we're not with you? I mean, if it has to go back to square one.
It has to go back, with respect, yes, that's our submission.
Thank you.
It can't stand within its structure as it is. That's our submission.
Thank you, Mr. Maritza. I just have one question.
Thank you, sorry. Oh, Justice Collopin, sorry. Thank you.
You took us through the business rescue plan and identified some definitions with regard to claims and to creditors, and then to the effect of the business plan would be that claims will become unenforceable once a distribution is made.
Yeah.
And you described that as a kind of trade-off. You said you get the right to vote, but that's the trade-off.
Yes. Why suggest...
My question to you is
Yes,
that would that be suggestive that, well, ordinarily you would not have had the right to vote, but this is a trade-off, and therefore on what you put before us, it was something unique that the practitioner and the creditors and affected persons arrived at, and that was an agreement that they entered into, and that was the basis on which the voting took place.
No, with respect, Mark, it was actually on the premise, the first premise is they had the right to vote, so there's nothing wrong. But on the premise, and that's where I started, I said, on the premise that they weren't allowed to vote, then one cannot achieve the order that the Court of First Instance achieved to say the vote was validly passed because of those terms which gave them the right. So if they had no right to vote, then that plan cannot stand. You can't take out certain people and say it was passed because the whole structure of the plan then falls apart because it encompasses voting. So it's, in that sense, it would be, in that sense, it could be seen as a, you can't have your cake and eat it. You can't say, I want the benefit, in Delama can't say, I want the benefit of option B being accepted, but I don't want their votes to be counted, because if their votes are counted, I'm out. Don't count their votes, I want to be in, but I want to be in on a plan which said, the core of the plan is everyone's voting. Can't have it both ways.
Mr. Maritz, just something that slipped my mind, but
Yes,
following on Justice Savage's question, the reality, and I'm raising this because there was argument about mootness that was raised by the BRP.
Yes.
What is the practical reality if this matter is sent back for a fresh vote, excluding all the post-commencement creditors from voting for the plan? Has anything been implemented post the High Court judgment, which I see was 2 October 2023, or the Appeal Court judgment of 29 January of last year?
Well, my understanding is, again, our plan, our option was not accepted, our offer wasn't accepted. I understand from what Ms. Mills said, nothing's happened except they've voted in favour of an extension of whatever has to happen, awaiting what's happening. So the BRP Council could answer that better, but as far as I know, nothing's happened, nothing's been implemented.
I thought I should ask the BRP, but I thought
Yes.
you may know. Yeah.
My understanding, because of course my client also has an interest, and my client has an interest because if it goes back, my client would want to make an offer.
Yeah.
But the position is, as our understanding, nothing's been implemented.
Thank you.
Is that it then?
That's it, yes.
Thank you, Justice.
Thank you. It's the same. Thank you, Mr. Simon. You may proceed.
Good afternoon, Justices. In addressing the time I have to outline our case, perhaps I can just begin with identifying the problem that has to be addressed, the issues that have to be addressed. There are two major issues and an ancillary or derivative issue. The first issue is whether post-commencement creditors can vote. The second issue, and that's a legal question as was said by the SCA, and then the question of whether, which is a factual question, of whether this plan was in fact adopted is the second question. But the third question, and was highlighted by some of the questions asked of Mr. Maritz towards the end of his address, is what are the consequences if post-commencement creditors voted here, shouldn't have voted? Is the answer that the plan has to be resubmitted to a meeting of creditors, or is it that the court is able to construct the answer based on the voting that did happen just by deduction of the disqualified votes? An important question for the creditors as well as for the BRP, the derivative question on the assumption that the court is against the interpretation placed on the matter by Mishwai and the BRP. Now, we have two judgments on the point. We have Court Ar Quo judgment, we have the SCA judgment, finding diametrically different conclusions, or coming to diametrically different conclusions on what should be a straightforward matter of technical interpretation. The problem is that the statute is not particularly clear, it's not helpful, it's certainly not dispositive in easy sense of this problem. Both of the judgments are very carefully reasoned. They use essentially an analysis of the same sections to come to the same, or to divergent conclusions. And another difficulty that faces us, perhaps an unnecessary and unfortunate one in a sense, is that the legislature toyed with the idea of giving clarity to this very question. Coming back to Justice Majid's question, which he's posed more than once, about the legislative materials. They toyed with it. They drafted something which would be clarificatory. They decided not to persist with it. The reasoning for it seems to be that it's already been historically dealt with, and so nothing needs be said, which of course is fundamentally wrong on every conceivable level, because even if Mr. Boert is right that the comparator is the insolvency law and business rescue is an alternative to it, you cannot just assume that matters which have never been addressed before with regard to which creditors qualify to vote are matters which are already so trite that they needn't be addressed. The other important issue, as raised by Justice Majid, is what to do with that material. Is it helpful? Is it relevant? Is it admissible? It's equivocal to start with, because although the question was posed and formulated, it wasn't adopted. So the intuitive reaction would be, it's not particularly helpful because no decision was made. The other jurisprudential problem which attaches to this issue is the question of what is legislative intent? What are we looking for? What are the permissible bounds for it, which Justice Majid tried to explore? There was a decision in the Constitutional Court which we referred to in our section, in our heads, last year on this question by Acting Justice Chaskelson, in which he seemed to accept that there are circumstances when you can justifiably look at legislative materials, particularly to try and find purpose. Of course, and he said one must do so with caution. In this particular instance, in our instance, the problem is that it results in an equivocal conclusion, if one even can deal with that paradox. But it's not actually helpful in any way at all. It shoots off in different directions like the two judgments do, and it's completely unhelpful. And so what's the fallback then? If the statute's not clear, the lack of clarity is compounded by another factor. The other factor is, of course, that we are required, the court respectfully is required to adhere to Section 7, which requires a balancing of interests. And Section 7 calls for some type of system to be employed, perhaps as an aid for interpretation, perhaps as an aid to implementation, but for an efficient system geared at rescue, in which interests of balancing of different factions of stakeholders are to be taken into account. But how do you do that? If the statute is unclear, if the legislature has avoided dealing with the issue, if the interests are in some senses aligned of different stakeholders and others not, then how does that help? So the conundrum that faces us is, and Justice Wilson at first instance diligently pursued this relentlessly in looking at what the particular provisions suggest, and he infers from some analysis of as to a direction in which it goes. But the SCA looks at the very same sections and says with equal diligence and care that it doesn't go in Justice Wilson's direction at all. And to make it even more complicated, there's a system that's postulated by the applicants, which is one we just don't accept. And it's a fundamental point of departure which distinguishes our position from theirs. The relationship between stakeholders, and in this instance, the post-commencement creditors and the pre-commencement creditors, is construed by them to be antagonistic, to be in competition, to be adversarial. And if one loses, the other gains, and vice versa. And those, he said, to be right and to be fair, and not to behave like some imperialist power, to be fair and do the correct thing. You have to look at those who were there when the problem came, not what he called the Johnny-come-latelys, as though they were in some tension with each other, where they didn't have mutual objectives. They may have differing interests, but they certainly have mutual objectives. And that is our guiding point, our point of departure here, because they're in a symbiotic relationship. They're not in an antagonistic relationship. The competition between them may, in one sense, be a division of limited assets, but in another, it requires a deep cooperative cooperation, ongoing cooperation, in which both of them act together in their mutual interest to ensure at best that the company is rescued, and if not at best, that they can get a better return in liquidation. So it's not a question of those who were there versus the Johnny-come-latelies. What it is what is the system that the Act contemplates which would best promote a particular outcome, which he labeled, Mr. Botha, as being a good outcome, a right outcome, a proper outcome, that is to protect those who were there when it all collapsed. But actually, there's only one good outcome. That's the wrong test. It's not a question of favoring creditors at one time against another. It's a question of a good outcome, and there's only one good outcome. And that is, will I, if you want to look at it from the perspective of the pre-commencement creditors, will I be better off at the end of this than I would be in liquidation? If I'm better off, I'm quite happy to accept the fact that somebody will outvote me, someone who's actually prepared to put money in, as Justice Matopo pointed out. I vote with my mouth. If I'm going to be a party to this, I want a say in this. I don't want anything that others have said, but why can we not together work out a best plan to achieve the good result, which is a better outcome than can be achieved if we don't, because liquidation will yield us nothing. If that means I must relinquish some voting power and accept some risk in return for the possibility of a better outcome, I'm not necessarily opposed to it. I've got nothing. When I'm a pre-commencement creditor and the axe has fallen and I'm about to go into liquidation, if someone is willing to put up the finance, I'm happy to sit with them. I'm happy to vote with them. Why wouldn't I be? Someone is going to take me out of the dreaded situation where nothing will happen other than a difference between assets and liabilities which will yield me a minimal return. If someone who wants to cooperate with me, wants to come into it, assume some risk, take some security, take the benefit of a possible statutory preference, may in that sense voluntarily and with knowledge of the fact that the situation is dire, if they want to come in and if it will result in a better outcome that they vote with me, I shouldn't have any natural resistance to that whatsoever. I should be only too happy that finance will come in, and if finance will come in, I have inherently a better risk, because we all know that Section 345 of the Companies Act postulates liquidation based not on solvency per se, but on an inability to pay debts, liquidity, lack of cash, lack of money to move out of the impasse. The only way to overcome the dire effects of liquidation is if someone will put money in so that the cash flow can improve, so that the liquidity can improve, and we can be in a better position. Now, my learned friend, Mr. Maritz, at the very last point he made, which I respectfully associate myself with completely, is made an exceptionally interesting point. He said this: look, let's just be very clear about what we're talking about when we're talking about voting rights here. At the day that the company is in rescue, there are pre-commencement creditors. Shortly thereafter, the practitioner is appointed. Then there are meetings and there's a process evolving towards a plan in which there will be voters and which may or may not be adopted and which will hopefully improve my position. But the only people who you can even conceive of, no matter how broad you want to define the notion of creditor, that could have a vote, are those who are actually creditors, not the ones which he used as an example. He used an example of the pre-commencement creditors sitting and voting. No need, he said, for a post-commencement finance person to sit in, because if he doesn't want to, he just won't finance it. They must present the plan, and then he'll have a look at it, and then he'll decide. So he doesn't actually need to vote. But the question, as Mr. Maritz pointed out, is that in that scenario, he's not a post-commencement creditor at all. He hasn't become a creditor. I mean, that's always an option. That may happen, and he's never a creditor, and then they can vote whatever they like. But he might look at it and accept it or reject it. But there's another category of post-commencement people who is a creditor by the time of the plan. He is a creditor who became a creditor immediately, because for the plan to have any prospect at all, some in a forced scenario, some voluntarily, are prepared to assume the risk, to put in some money immediately, even before the plan has been formulated, just so that we don't go into liquidation on day 2. It may take various forms. It might be a banker who says, okay, use the cession of my book debts, I'll swap that for post-commencement finance. It may be a host of people who are already in, or it may be newcomers who prepare to say, I'm in, I'm going to take my chances with you. I see opportunities with you. The notion that when the plan is then voted, that person who is already in the estate, you may call him, if you want to, a Johnny-come-lately, you may call him the ones who have always been there and were there when the crash occurred, but actually you can only call him one thing. You can call him a creditor, because that's what he is. He's expecting to be paid money in due course, and hopefully with a successful plan which will result in a good outcome for the pre-commencement creditors and a good outcome for him. That's the hope. But to deny that person a participation in the vote that will determine his future is commercially impractical. What it's going to do is it's going to cut off the participation. It's going to have a chilling and dampening effect on the willingness of the crucial element of post-commencement finance to emerge out of the shadows and try and resurrect this phoenix. You're going to cut them off, because why should they if they're not voting? The answer to that is not that you get a super preference under Section 135. It's not an answer, because if the plan that is put in motion without my vote as a post-commencement creditor fails, there may not even be enough to pay the business rescue practitioner, never mind anything else. My super preference can count for nothing. The most overwhelmingly important factor in driving a conclusion to this very difficult matter is the necessity to ensure the good outcome, and that is to enable participation and not exclusion. And so our submission to you is, when you read these various sections that everyone has debated at length, you would look at them in that light, not in the light of competitors and Johnny-come-latelys. It's in the light of what is going to be the best to promote what the Act requires, which is a better return than liquidation, at least, but hopefully a rescue. Now, the way my learned friend Mr. Buerta goes about this argument is he comes at it from the other end. He says, but listen, hang on 1 second. There's a big danger here. The big danger is that if you let these Johnny-come-latelies in, they might capture the plan in the sense that they may be willing to put in so much money that they can exceed the 50% independent creditor level, and they can achieve more than 75% of the votes. And that is going to be a disaster. And he says that the fear of the exception should be the governing rule. And respectfully, that's just not right. If the problem, and I'll deal with what he posits as a problem, if the problem is not, is one that exists, the solution is not to deny the measure. The solution is to be found in a remedy. His solution is deny the measure because of the exclusion. What we're saying, if it is a problem, and we don't think it's a problem for a reason which I'll tell you now, don't deny the measure, because the measure is conducive to what is actually intended as an outcome by the Act. Now, with regard to that, what we say to Mr. Buerta is this. You may try and hijack a business rescue. And he says in the real world it could really happen, and he has a case to illustrate it. The problem that there is that there is then a capture, that one person in their own interest has overwhelmed it, and it may or not be a bad thing. It will be a bad thing if the result of that is that creditors get less than they would get in liquidation. If that plan yields a result to creditors which is less than liquidation, it's a bad thing. If that plan, adopted as it is, with all its flaws and even with a capturer, still results in a better return for creditors, it's not necessarily the evil that he postulates. But that said, assuming that there's an element of distaste that accompanies that, assuming that that's commercial marauding, assuming that hijacking in that sense is not a value that this court would endorse, assuming that that is the case, then the common law has a solution to it. It's well established in the law of insolvency, for example, that if you bring a sequestration application for an ulterior purpose, it will be rejected, will not be endorsed. If a person affected by it, and particularly if they're affected by it to the extent that the return that they'll get is less than a liquidation, we know that in a business rescue plan you have to do a calculation of what you would get in the liquidation in order to make an assessment, clearly, of whether this business rescue plan has any legs at all. If it doesn't, the rescue practitioner may be obliged to say, look, the best I can do is a plan which condemns this company and does not posit a way of resuscitation. I must go to court and say I can't fix this. It must go. But if the only option is some plan which does not, for example, yield an acceptable return to creditors, better than liquidation, and it's a hijacker who's behind it, the court would not endorse that. At no stage would the court endorse a plan which will put creditors at the instance of a single person in a worse position that they'd be in liquidation. If they can find a way to do better than the plan, then they won't vote for the plan, and if the plan goes through, then it's problematic for the hijacker. No court is going to tolerate that. In a case called Hudson versus Hudson in 1927 in the appellate division, as early as that, it's been recognized that using the rules, and you can take the statutory rights as well for that matter, for an ulterior purpose is not acceptable. In the appellate division, there's a case, and I'm sorry, I just don't have the reference to it, Gorfil Brothers, Gorfil Brothers versus Gorfil, Gorfil, an attempt was made prior to the Constitution to take a costs order in litigation, attach it, and seize it in execution, buy it up in execution, and end the litigation against you. And there's an analysis in that case, and particularly in the court quo in that case, about the limits of using statutory rights for ulterior purposes. It wasn't reversed in that instance, and it was pre-Constitution. But I think there would be little doubt that it would not survive constitutional scrutiny now. And so the system is not, as Mr. Botha says in despair, remediless against a hijacker. There exists remedies. And if refinement of remedies is required, that's a better solution than denying creditors a right to participate just because they are what he calls Johnny-come-latelys. So against that background, if I can maybe just refer to some of the sections that have occupied this. I don't want to spend much time on it. They've been debated by everybody at length. There are ways to read them, as Mr. Botha has. There are ways to read them that would yield a different outcome, as the SCA has. It's not an easy or particularly comfortable exercise. Now, I think the starting point is probably to look at 7K, which, as I said earlier, provides for the efficient rescue and recovery of financially distressed companies. We know from the more general definition that that's assessed by a 6-month window, either of an inability to pay debts or a matter of insolvency, in a manner that balances rights and interests of all relevant stakeholders. The next place to go in this journey through this is section 128, which is the general definition section, which establishes the notion of an affected creditor, which is a creditor of the company without the restrictions that my learned friends would like to read into it. There's also a definition of an independent creditor, who is a creditor of the company, and it shouldn't really be a related party, which makes sense. There's also a definition of voting interest, which requires appraisal. But then, if we go a little bit further, we find the defining provision about the rights of post-commencement financiers. So that one is at section 100. Well, let's go to participation of creditors would be the next logical place, which is 145. So a number of the justices have raised the question with my learned friends about what to make of the wording each creditor. It's a deliberate wording. It may, as Mr. Botha would have it, possibly linguistically mean that it's every one of them. It may mean each one individually, or it may mean every possible creditor. It's not clear. But each of these creditors, without express limitation, and that's the line that the SCA adopted, there needs to be an express limitation for a very broad definitional clause. They look at the things respectfully that they can do. They're entitled to formally participate in the business rescue proceedings to the extent provided for in this chapter. Whatever that may mean. So if you want to deprive them of that, you'd need to be looking for a deprivation in this chapter, which really doesn't exist. There's a deprivation, as we know, with regard to employees, which Justice Wilson interpreted to mean and the attempt was made by my learned friends for the applicant to make the same sort of argument, that because the employees as post-commencement people are excluded, it should follow that post-commencement creditors should be excluded. But of course, the converse is equally true and in fact more compelling, that the legislature found it necessary to deliberately exclude it, which would suggest the opposite, that in fact it is included. The right to vote is included. The only people who are deprived of it are employees in the category of post-rescue finance. But they could equally have deprived other post-commencement creditors from that, but elected for whatever policy reason they decided on not to do that. We also know in sub 4 that what they're entitled to do, or perhaps even in sub 2 more pertinently, in addition to the rights set out in subsection 1, not only have they the right to participate, they have the right to vote. The creditors without restriction have the right to vote, to amend, approve, or reject a proposed business rescue plan. In the proposed business rescue, if it's rejected, they have a further right to propose the development of an alternative plan or present an offer. Why is the Act doing that? It is to realize the ultimate objective, that creditors should be engaged in an iterative process in order to find the best outcome through whatever best business rescue plan is available to them. The business rescue practitioner has got to formulate it and coordinate it and his administrative duties. But in regard to all of that, the idea is for it to evolve, for there to be engagement, for there to be amendments, for there to be discussions, for there to be a vote. And there's nothing whatsoever in this wording which would suggest that that vote is limited in the way that they'd want it to be. That limitation seems to stem fundamentally from this problem they have of the marauding business rescuer. That problem must be addressed in its own right. It's not a reason to interpret the section restrictively. It's not a reason to deprive very broadly based, policy-driven objectives. The next place to go would I don't want to go through the rights of employees in 144 because it's already been addressed. Perhaps Justice Rogers raised such an intriguing question. The question of whether the practitioner is then a creditor. If I can just refer you to section 143 about the nature of it. So the difference between a practitioner and other creditors is he is an administrator of the plan. His function is a statutory function, which is to create together with, or as a product of engagement, investigation, he must formulate the plan. The notion that he could be a voter in the plan because he gets paid as a cost of the business rescue would respectfully be an astonishing one. I imagine that creditors would be astounded if the person promoting a plan was voting that plan in his own interest because money is owed to him due to his administrative functions in the cost of the business rescue. It would be an astonishing thing to see a business rescue practitioner do that.
Simon?
I beg your pardon?
Your time is up.
Thank you, my lady. I'm happy to take questions. I'm sorry that I would have perhaps gone a bit deeper into it, but I'm happy to deal with it. The arguments have been made by my colleagues.
Yes. The applicants say that the post-commencement financiers should be excluded from voting because they enjoy the protection under Section 135 and their claims are not compromised under Section 154(2). What is your response to that?
My lady, so the fact that you get a super preference does not mean that you'll get paid. If it's a bad plan that it's adopted in your absence, if you're a post-commencement creditor, and it fails, you may never even receive any money as a super preferent creditor. So it's not a solution to that. The reason why their claims are not compromised in that sense by the outcome of a plan is you need an inducement to get them into the rescue. And so they should see the potential of light at the end of the tunnel, even if the plan does fail, so that they can persist with their claims and not be compromised, because their claims, unlike those that existed pre-commencement, are the ones that enable the business rescue to happen. So there are good grounds, respectfully, for distinguishing between their position and other creditors. Mr. Maritzes has said that in his view, he thinks it follows naturally that if they vote, they should forfeit that. That's his view. That's a tenable interpretation. My sense of it is that it's a design to protect them in this way, so that they will not end up being in the position of the pre-commencement creditors in another failed business venture. So it's also necessary to attract them. My lady, the difficult, on the one hand you can say, and with some force, that pre-commencement creditors, as Mr. Botha says, have been there. They were there when the collapse happened. They are crestfallen. They are devastated. The fact that one of their debtors is not going to pay and it's in a moratorium and there's a business rescue is devastating news to them. And they are anxious to try and find a way out. They know, as all business people do, that when it's collapsed because of an inability to pay debts or financial distress of some or other sort, money is is their only salvation. And so if you put any dampener on the willingness of practitioners to provide that finance and take that risk, you should make it attractive. And perhaps that's what the legislature intended. Maybe Mr. Maritz is right. Maybe they can't have both, but my submission to you is that that may have been the design, and for good commercial reasons too.
Applicants argue the cramped down argument.
Well, I'm not sure what they mean by that. If they meaning the hijack situation in which they can acquire more than 50% of independent voting interests and they can accumulate a claim, and if they then take over, assuming that they're not intending to do this for an ulterior purpose, assuming that they are in a business rescue, and in this particular business rescue, for example, Eskom has an enormous claim, which overshadows everybody and anybody. It's undoubtedly an independent claim. In that type of scenario, if they were to provide, I'm not saying they have, I'm just using a hypothetical example, if they were to provide post-business rescue finance and become more than a 50% independent and control more than 75%, there's no harm in that. If it will result in the good of a better outcome, there's no harm in it. Other corporate marauders, if there be, are constrained by the common law, and they can never expect to get away with a plan approved by them on a hijack basis which yields a lesser return to creditors than liquidation. It's not going to stand. So it isn't as real a danger as is postulated. It will work its way through. And you shouldn't take the benefit of what could happen in consequence of that and say, I'm not going to recognize it because of the risk, the thin risk of a marauder. You shouldn't limit the rights of those who need to participate to make the system effective.
In relation to the factual inquiry,
I'm sorry, I can't hear you, my lady.
the last point that I want to raise is relates to the factual inquiry. If the post-commencement financiers are supposed to vote, my understanding is that some did and some were not allowed.
Yes.
that would mean that that process would be irregular.
Yes. So,
And then what would be the consequence of that?
so Mr. Maritz raised an issue which is of fundamental importance, not only to your ladyship's question, but to the response, the derivative issue of what must happen if you feel that a class of persons who are PC creditors, PCF creditors, voted, shouldn't have voted, and without them there has been an achievement of the plan. Assuming you say, well, I don't think they should have voted, and I don't believe that the Act intended to allow PCF voters to vote the adoption of a plan, then the question becomes, what must then happen? Now, this plan, in its terms, postulated the existence of a vote vesting in both the pre- and post-commencement finance creditors. And Mishra, according to, as Mr. Maritz has explained, was not the only PCF creditor. It's not that the majority would or wouldn't have been obtained in their absence. The question is the revolutionary undermining of the very basis of the plan put to the vote. If the very basis of the plan has changed, in that all creditors who were looking at this plan and who all agreed it or disagreed it, based on the assumption that within this plan, post-commencement creditors would be voting, if you decide they couldn't, and without them the majority is achieved, or if you decide that they can and there is no majority, if you need, on Justice Wilson's assessment of the matter, if you need to deal with the fact that there was a majority absent the ones who didn't vote, you've undermined the plan completely. The entire landscape has changed. It's no longer the plan that was ever presented. And for that reason, it has to go back. And that's why we say that it's a form of judicial re-engineering of the vote. You're taking a plan, you're eroding all the pillars of the plan, the most central pillar about which this court would make a finding, saying that isn't part of the plan, could never have been, changing the plan materially, and then saying, well, it's now a changed plan in which PCF creditors can't vote, but I'm regarding it as adopted, even though the landscape has changed so fundamentally. I mean, after all, the basis of a plan, maybe it has contractual elements, maybe it has quasi-administrative elements, but on your lateship's question, once it's put to the vote, the process of the vote must then be honored, and it's not a question of tallying numbers, it's a question of establishing a principle. Once the principle has been established, if you are against us on the principle, it should be remitted. It shouldn't be decided mechanically. We've given you a couple of cases about that. They're cases relating to elections, where elections were held on the wrong assumption that people could vote and then couldn't vote. Sometimes the courts have been prepared to accept by just doing arithmetic, but other times they have not. So we've given you examples. I think we gave you 2 examples of cases where that is. I'm not certain if that addresses your ladyship's issue.
Yes, thank you.
Thank you.
Thank you. Justice Mato.
Thank you. Thank you, Justice. I'm sorry, my lady, I forgot to mention, I'm not persisting with the preemption point. It's not a good point. Mr. Mills doesn't have to worry to address you about that any further.
Is this your laptop? Thank you. Thank you. Thank you, Madam Justice Mhlantla and the court. I'm endeavoured to be as brief as possible. There was an argument made by Mr. Maritz that our case was had somehow changed, that we'd suggested that there's a creditor for one definition a creditor can mean something else in a different context today, but that was not previously our case. That's always been our case. Paragraph 72 and 73 of our heads of argument, we make it clear that when you look at the word creditor, it is context bound, and we refer to Henoksburg in that context. And that's been consistently the position. Those heads, that passage of the heads is very similar to what we had in the Supreme Court of Appeal, and it's the same argument I made before Justice Wilson in the Court of First Instance. So we've never said that post-commencement creditors as a general proposition are not creditors at all. What we emphasize, and I pick up on passages that were also read by my learned friend Mr. Simon, when he says the creditor has a right to vote, and he says this with reference to section 145 sub 2. But what we seek to emphasize is this: that section does say that creditors have a right to vote, but it is in accordance with that part of the chapter. So, in other words, what you see in section 145, 1 refers to formally participate in the company's rescue proceedings to the extent provided for in this chapter. And sub 2, which my learned friend referred to, you've got to read the whole sentence. It says, in addition to the rights set out in subsection 1, each creditor has the right to vote, to amend, approve, or reject a proposed business rescue plan in the manner contemplated in section 152. And so the contemplated is your qualifier. It's not everything, because that manner is qualified under 152, which again references voting interests. And so there's this difference between who has a voting interest and who is a creditor with a voting interest and who is not. So we say that that's a difference. The other submission made in regard to the plan, it seems to be a suggestion that this plan gave rights to post-commencement credit, or rather compromised even post-commencement creditors' claims. We've read the definition of claim. We respectfully submit that's not what it says. It doesn't say that, because when you read 23 of the plan, which my learned friend Mr. Maritz took you to, and for reasons of time I'm not going to take you there, but you'll see it talks about the word distribution to the creditors. That distribution to those creditors with the claims can only be the creditors, can never be the post-commencement creditors, because they're going to be advancing amounts, and you would have seen that from Ndalamo's presentation earlier. They're going to be putting in 300-odd million as post-commencement finance. You can't read that, so the words just don't say what is suggested. It would in any event, to refer to the Vantage Goldfields South Africa Arkomanzi case, the 2023 volume 4 SA 568 SCA version of it, where the Supreme Court of Appeal there dealt with the question as to whether a business rescue practitioner could, for instance, attribute to himself powers to amend a plan. He can't. He only has the powers in the Act. The Supreme Court of Appeal said, in effect, that that would be ultra vires. So the powers to determine who has the vote, to get to the question Justice Savage posed to my learned friend, is set out in 140 for subsections 4 to 6. I'll get the reference right now. But it doesn't mean that he can decide who actually gets to vote. It's 145, 4 to 6. So those are the rights that are recognized, because again, the definition, it's important, the Act has a definition in section 128 of voting interest, and that means an interest as recognized, appraised, and valued in terms of section 145, 4 to 6. To pick up onto the point that Justice Rogers raised with my learned friend about the moving feast, but that's exactly what happened in this case. That was part of the problem. You'll see in the founding affidavit, there was originally a vote, and then the vote was cancelled. And when you see the report that was attached, that's FA2 to the founding affidavit, it says, well, we counted, but there were things coming in all the time, additional proxies, this claim, that claim, and that was part of the problem. So there wasn't really a cutoff. It was this constant moving, and that's what caused the difficulty. A submission was made about the concursus creditorum. It seemed to suggest that even in liquidation, you have a post-commencement creditor. That's simply not so. The concursus creditorum in a company is determined by section 348, And the decision in NAL NNO versus the Master, 2002, Volume 3, South African Law Reports 354, SCA, the Supreme Court of Appeal said that even in the case where a petitioning creditor got a provisional order and then it was discharged, and another creditor on that same day got a final winding up order, the concursus goes back to the date of the presentation of the notice of motion of the first application. And that's also dealt with in paragraph 5.20 of Meskin's insolvency law. So that there's no debate about that. There's no later creditor. That's your concursus. That's your cutoff date. And that's where we submit is the case here. As regards, I'll leave the debates around the creditors and the voting to my learned friend, Mr. Miltz, and he will deal with those issues. But in regard to what I understand really to be the substance of what Mr. Simon is submitting is this, is that there is a sufficient catch-all somewhere else in terms of the common law. It's good that he mentioned Brummer versus Gorfel. He made a mistake, though. That wasn't in a pre-constitutional era. In fact, you will find the case reported at 1999, Volume 3, South African Law Reports 389, Supreme Court of Appeal. And what had happened there, a cost order was obtained and they brought the claim against them. They then sought leave to appeal to the Constitutional Court, which was refused, and that's reported at 2000, Volume 2, SA 837CC, which demonstrates exactly the difficulty even in the constitutional dispensation. You see, when a post-commencement creditor votes, he's not voting as some kind of competition, he's voting his interests. It's not an ulterior motive. There's only one motive. I want to get the business. A court will not set that aside without there being a protection mechanism within Section 153. But Section 153, and Mr. Simon did not suggest otherwise, only is in the event of the plan being voted down, not approved. And that's the fundamental difficulty with all of those arguments. We're not trying to suggest that everything is a competition. All we're saying is that everybody has a right to vote their own interests as far as pre-commencement is concerned, and other mechanisms are created for post-commencement. And to pick up on the point that was raised about employees, it seems to be common cause amongst all the legal teams that post-commencement finance employees don't get a vote, but somehow other creditors do. And that's the point that Justice Colopin raised with me. It is strange, and it could never have been the legislature's intention to single out employees. There can be no justification for that. So therefore, the reasoning of His Lordship, Mr. Justice Wilson, in that regard, we respectfully submit is sound. In essence, what Mr. Simon's argument amounts to is this, that there is a chilling effect that's going to be created by not providing for post-commencement financiers. We say that's not so. That's not been so. The Ndalamo offer in this matter is an example of it not being so. It's not the American experience. It is simply a matter of balancing all rights and interests of all stakeholders. And in the same way as a business rescue practitioner, one would jump at the idea of a business rescue practitioner being able to vote because he is a creditor. Why does that suddenly differ when it is a post-commencement financier who's putting up the plan? And now he can vote on the very plan that he's putting up. It doesn't follow. And so what we say is the suggestion that this is going to somehow be what my learned friend Mr. Simon does, he'll be a very good mediator, I have no doubt, is that's what you try and achieve in mediation. That's the ideal thing. We all work together and that would be an outcome. But that would be in a perfect world. Unfortunately, that's not what happens in the real world because people have different interests. And that's why the balancing effect is created by giving the rights as we've suggested in our argument. I believe those were all the issues I needed to cover. I have 34 seconds. Mr. Sachabas Mahapi says
I raised with council the question of remittal
yes.
as an option here, because it seems to me that if the argument is sound, that all post-commencement creditors should then be disqualified from voting if your case is sustained,
yes.
your argument is sustained, then we must put all of them together in excluding them from voting. do you accept that in that instance then we should remit for a fresh vote?
It would seem so, Justice Majid. The evidence, we say there isn't evidence to support that, and I'll leave that to Mr. Milts to address, to support that proposition. My understanding always in the calculations made were always on the basis that no post-commencement creditors were voted, and that was my understanding based on the schedules that were floating around at the time, which is why we had the common cause position in front of Justice Wilson. So subject to that, but of course the principle is correct, that if that is so, everybody who is post-commencement shouldn't vote and their vote shouldn't be counted. If it needs to be sent back for that reason, it's no difficulty, but that is another reason why our argument with respect is sound, because the moving feast problem that Justice Rogers raised is not really an issue, because you'll have the same creditors who were creditors before will vote again. And so if this court comes to the conclusion that they can't decide on the papers, that if we are correct in our proposition as far as Part A, the legal question is concerned, as Mr. Simon framed it, but Part 2, you can't decide the factual question, then that certainly is a remedy to send it back for a revote on those issues. And of course, if we're right, it'll be those creditors who were there pre-commencement, and it's not per se a difficulty, but it may be a different vote. I hope I've answered your question in a manner that's helpful.
Yes, it seems to me that if you just take Bopelo mining, the 27%, and split them in half pre and post-commencement, it's a significant factor in the calculations. And it seems to me that, and correct me if I'm wrong, I got lost in the record, in the voluminous record, but it seems to be that if Mashwai only is excluded, then it just barely push it over the threshold, isn't it?
Yes, they barely pushed it over the threshold.
Just over 75%.
Yes. But if I may just answer, the only thing I could find on the Boipelo is you'll see that there's a schedule we put up to the papers. I'm not saying that it's 100% accurate, and as I said, I'd leave this to Mr. Milts. But on the calculation that we did at 131A, it's in Supplementary Record Volume 1, you'll see that the Boipelo mining, which is, I don't know, 1, 2, 3, 4, 5, 6, 7, 8, 9, it looks like the 10th item
Sorry,
down.
just the page number in the...
113A and Supplementary Record Volume 1. Their Boipelo mining is at 49 million on this calculation, and this calculation came to then the figure, as I saw it, was 76%. But all I'm saying is that those are the reasons why there's maybe toing and froing, and I believe Mr. Milts will address it. Our concern was absent something on papers so that we could deal with whether Boipelo is counted or not counted. It doesn't assist them because the common cause position in front of Justice Wilson was what it was. They suggested they were going to supplement, they should have, and then we would have all known what the position is.
What do you say of Mr. Maritz's point that if Mshweyo, well, this is for purposes of the 43 million post-commence, the post position, if he's not a creditor, he can't be bound by the plan in terms of Section 152. So that one day after the acceptance of the plan, he can just undo the plan again.
Yes, it was an interesting proposition, but it doesn't actually work in the real world. So what would happen is, as Justice Rogers pointed out, everything that is pre-commencement, there's a moratorium. They can't pursue it. But there's also a general moratorium that they can't. If the business rescue plan is approved and you haven't dealt with people going forward, it's almost a new, I've had to deal with this kind of situation. It's an novice actus interveniens, as it were, because now you haven't actually put a plan in place that will allow the rescue of the company. But that you can't compromise the claim is not a fault of anything other, it's just that the legislature says you can't, because 154 sub 2 says unless they agree under 154 sub 1, it's only pre-commencement creditors that are compromised. So that is a situation that does arise in practice. It is something that'll happen, but that just means you haven't properly catered for it in your plan, because then the business rescue is not able to continue as a going concern going forward. But those are new creditors. They're not old creditors. The purpose of the business rescue is to resolve the situation to that particular cutoff point. So it's not something that's likely to happen in the real world unless you haven't put together a proper plan. But in theory, that is the rights that you would have because your claim is not compromised, and that's because 154 sub 2 expressly says that, unless you've agreed in the plan. So if you haven't catered for it in the plan under 154.1, it is a potential that can
Can you
arise.
just go to section 145, sub 2 and 3?
Yes.
So, in addition to the rights set out in subsection 1, each creditor has the right to vote, and if the plan is rejected, a further right to propose the development of an alternative plan.
Yes.
So, now, Mshweya wouldn't be entitled to vote. Let's just forget the pre-commencement debt
Yes.
on that scenario, because it's not a creditor. Now, the plan is rejected, and sub 3 provides that the creditors of a company are entitled to form a creditors committee,
Yes.
and through that committee are entitled to be consulted by the practitioner during the development of the business rescue plan.
Yes.
Would that then mean that Mshweya would be precluded from participating? Because it's not a creditor, so there might be a difficulty with the plan, and they've got to, but this is now.
So if it was not a creditor at all, it wouldn't be on the creditors committee. On its version, it's a post-commencement creditor, and so it would be on the creditors committee. There's no difficulty. It just doesn't have a voting interest. So I don't have a problem with a creditor being part of the creditors committee. It's because 145 sub 2a says, as contemplated in 152, which is the voting interests. So it all goes about voting interests, but it doesn't mean that they're isolated or out in the cold. They would still have a say if they are a creditor. And so that would work for Mshweya or anyone else who is a creditor, because that you would have a voice, as it were. Thank you, Justice Mhlanga.
Yes, Mr. Metz.
Thank you, Madam Presiding Officer. I have 4 short submissions to address in reply. The first deals with Justice Opperman's last question to Mr. Botha, because the argument of our learned friends was that it wouldn't be, it was Mr. Maritz's answer that the creditor who's a post-commencement creditor wouldn't be bound by the plan if he didn't vote on it and could apply for liquidation the day after. We say that that reading doesn't work on the Act for the reason that even though they won't have voted, even though post-commencement creditors will not have voted, nevertheless, in terms of Section 146D, they are still bound by the plan that's been approved, because for the purpose of that section, they are a creditor. In their capacity as a creditor for that section, they are in the same category as a holder of securities in the company who has been precluded from voting because there was no change to the holder of securities' rights, which is expressly permitted only in terms of Section 152.4. A holder of securities is bound regardless of whether he's present, voted, or in the case of creditors, had proved claims against the company. If we, Section 1, I'm getting my sections messed around, I'm rushing, I'm going to slow down a little bit. Section 146D limits a shareholder's vote on a plan. Limits a shareholder's vote on a plan to voting only if the plan would alter the rights associated with the class of securities that is held. That's the position of that shareholder. Section 152.4 says that the shareholder is bound. That shareholder is bound regardless of whether he's present, voted, or in the case of creditors, has proved claims against the company. So we say that regardless of whether the post-commencement funder voted, we say he shouldn't vote, shouldn't vote. But there's nothing that follows from the wording of this section that requires him to be treated on a different basis to a holder of securities who also hasn't voted, who also hasn't attended a meeting, or in the case of creditors, who hasn't proved a claim. He's bound. They can't liquidate the next day. Mr. Simon's argument on the purpose of the Act, including Section 7K, while laudable and obviously giving meaning to the section, of course is frustrated by the uncertainty that's created by legislation that's been shoddily drafted without care, so that the procedure to achieve the objective that the Act requires in Section 7K is frustrated and cannot be achieved, which is why we are here. I know that Mr. Maritz alluded to several judgments dealing with this, dealing with criticism of the Act, but just to give substance to that criticism, Justice Leach, in a judgment that's referred to in, I beg your pardon, that's referred to in footnote 49 of our heads of argument, it's the case of African Banking Corporation of Botswana Limited versus Kariba, said at page 22 of that judgment in paragraph 43, I do not believe it is unfair to comment that many of the provisions of the Act relating to business rescue, and Section 153 in particular, were shoddily drafted and have given rise to considerable uncertainty, which is the type of uncertainty that we are dealing with here. And later on in the paragraph, he said it is therefore not surprising that Dr. A. Loubser has expressed the view that it was regrettable that the drafters of the provisions regulating the new rescue proceedings did not exercise more care, and that the unclear, confusing, and sometimes alarming provisions regulating the business rescue proceedings will certainly not assist in making the procedure more acceptable or successful. So that has to happen, and unfortunately it will require this court to give meaning to these confusing provisions that we are cavilling with in order for the object of Section 7K of the Companies Act to be achieved. Then finally, Justice Majid, in respect of the question of the applicability of international law to the determination of the issues in this matter, we agree with the submissions that have been made that regard can be had, but it must be very cautiously considered and not unduly emphasized. But in our heads of argument in paragraphs 48 to 51, and I'm not going to take you there now, we refer also to South Africa's membership of Incotrol and the insolvency documents that are promoted and the principles that are all referenced in those paragraphs of our heads of argument, paragraph 48 to 51, which is a different category of consideration that needs to be taken into account in interpreting the Act in accordance with the Constitution. It's not just foreign jurisprudence, it's also South Africa's membership of international treaties and agreements that needs to be considered. And I think it is fully set out in our heads of argument. And then as to the final point relating to the calculation of the claims and whether or not the threshold was achieved, our complaint is the same as that of Salanganu, that there's no affidavit in the papers that sets out what Mr. Maritz so eloquently explained in his argument today with reference to documents. That really is a travesty, because if it was in the papers, we could have dealt with it fully. I know there is a prima facie view that suggests that there were post-commencement claims that were allowed to vote and weren't excluded, as Mr. Maritz submitted. Mr. Botha has referred to the report of an expert that was attached to one of the Salanganu affidavits, which shows that a 76% majority was achieved, and it also includes only half of the claim that Mr. Maritz said was 100 million rand. Unfortunately, though, it probably opens more difficulties than it puts to bed, because in the court a quo, and until the Supreme Court of Appeal was reached, there was an attack on the sessions of the claims that were acquired by Mshwayi that formed the part of its pre-commencement debt. Those were abandoned, and to the best of my recollection, the schedule that shows 76% approval having been obtained in the vote excludes the ceded claims that were then abandoned. But again, the papers haven't travelled down these roads, so it's very hard to deal with them in argument. On that basis, I can only submit that if the court is not satisfied on the factual issue, which we addressed in argument earlier, then, and is not prepared to grant the relief that we seek in the final paragraph of our heads of argument, which the order granting leave, upholding the appeal, and implementing the Indalamo offer to acquire the business, then the proper course would be to remit it for a revote, subject to the rulings that are given or the interpretation that's given of whether or not post-commencement funders can or cannot vote. Madam Presiding Officer, we have nothing further unless there are questions.
Thank you, Mr. Mills. Looks like there are no questions for you.
Thank you.
Thank you very much for the submissions.
I'm sorry.
Yes, Mr. Simmons?
Can I just give you a reference? My learned friend referred you also to the Constitutional Court decision in Gihwala and Brahma. The citation for it is 2000, Volume 2, SA 837 in this court. And in the case, it appears that the facts arose before the Constitution, before even the interim Constitution. But the court did remark in this case that on the facts that I've given you, there was nothing that would attract their attention to revise the common law on it. So perhaps it's a bit equivocal, but what I did say to you was not incorrect.
Thank you. The court is going to consider the matter. Judgment is reserved. The court adjourns.